May I, Your Lordship?
Yes.
Lordship, I beg to mention item number 7, Your Lordship.
7.
Yes, this matter to be listed after 2 weeks.
Why?
2 weeks, Your Lordship.
No. 2 weeks.
Yes, sir.
I thought of disposing of this today.
Yes, sir.
Hmm.
I actually here
Okay.
Estapin is appearing, Your Lordship, senior government. He's
What? Some clarification was to be done.
Yes, Your
But
Lordship.
that is clarified only
Oh,
by the legislative act. Okay. Next week?
okay, Your Lordship. Okay, Your Lordship, next week.
Next, we'll try next week. There's nothing much otherwise.
Okay.
Mm. Okay. On the prayer of Ms. Pangu, Land Government Advocate, on behalf of the additional,
Senior government advocate,
okay,
Estapin.
on behalf of Mr. Estapin, Land Senior Government Advocate, for the respondent, state respondent,
Yes, Your Lordship.
not being objected to by Mr. K. Lawyer, Land Council for the petitioner. List the matter next week. Next week
Yes.
means
Monday.
next Monday.
Yes, Your Lordship.
Next Monday. Monday may not be possible. We'll say Wednesday.
Okay, Your Lordship, Wednesday.
Just a minute, huh? It'll be next Monday would be
7th, Lordship.
31st.
31st, it's okay. Lordship.
No. 7. We'll list it on 7. Okay,
Okay, Your Lordship.
7. Okay. The interim order passed earlier shall continue till then. Okay.
Yes, Your Lordship.
Yeah, Your Lordship.
Yes.
Your Lordship, I may be allowed to mention item number 18.
Item 18.
Yes. I'm putting appellant here.
Okay.
Since conducting counsel, Mr. Arsonar, he is not available. He's out of station. Therefore, I pray for an adjournment.
Mr. Kamba, Land Advocate, Land Council submitted the conducting council, Mr. Arsona, is out of his station. Therefore, pray for adjournment of the matter for
It may be listed after 3 weeks.
3 weeks. The prayer having not been objected to by the
I have taken the consent, Your Lordship.
council for the
Yes.
respondent, he is allowed to establish the matter after 3 weeks.
Yes.
Okay. Yes. What is the offense involved? Monday? Why? You'll be arrested only if you have done it. If you are involved, you'll be arrested only. Then why you're apprehending? The co-accused, how he became co-accused? Yes, then you are accused. Are you named in the FIR? Monday? I don't see it urgent. Have you filed it? Already filed? Okay, let us see.
May I, Your Lordship?
Yes.
I'd like to also mention one unlisted matter. The same case.
Same case,
Yes, Your Lordship.
same order.
Lordship, I beg to mention item 9, 10, and 11. Here, learned senior counsel PJ Sekia will appear, but because of personal difficulties could not appear today. So may I humbly pray the Lordship matter may be fixed on 7 October, Lord.
7th. I think
7th.
so many things, so many matters have been fixed. 7 election petition also there. Election petition is also there.
7 October.
After that,
10, 7, 8, and 9 election.
9th.
October, Lord. Not
October.
September.
Okay, no problem. Okay. As
7 October.
on the prayer of Mr. K. Lole, Learned Council. You inform the other side
Yes, yes.
with the consent of the Learned Council for the respondent. List the matter on 7th October. Okay.
Obliged.
Deeply obliged.
Item number 1,
My lord, if I may.
Yes.
My lord, by this instant civil revision petition, the petitioner is assailing the impugned judgment passed by the learned civil judge, senior division Alo, my lord. The impugned judgment is at page number 113, my lord. By this impugned judgment, my lord, the learned code had condoned a delay of 295 days in preferring in the civil appeal 10 of 2024, by which the respondent herein had challenged the Kava decision passed in 2023, July 2023. So by passing this order, the delay was condoned and the connected appeal was directed to be admitted for hearing, my lord. So, my lord, if I may give the basic facts, my lord. The brief facts are that, my lord, in the year 2022, the petitioner herein, he had applied for a land possession certificate before the learned ADC Kamba. Now, after he had applied for the LPC,
Never decided.
no, after he filed for the LPC, the ADC issued a public notice
Raise objection.
for raising objection.
Okay,
So
then
they-
he filed before the Keba.
No, Your Honor. Actually, my lord, actually the respondent, he filed an objection saying that the petitioner herein is claiming some part of the land that belongs to the respondent inside this LPC.
That is what I'm saying.
But that's what, Your Honor. Objection was raised by the respondent.
The petitioner
Yes, my lord.
lodged complaint before the Keba,
Yes, my lord.
saying that he has no right to raise objection
The respondent, yes.
because the land is under his possession.
Yes, my lord.
This is ancestral
Yes, my lord.
since 72.
Yes. So,
Okay, then
so the
Keba decided in your favor.
in the petitioner, yes, in my favor, my lord.
Okay, then the appeal filed.
Appeal filed before the circle head Gauhati, my lord. Because
Circle.
there is the nomenclature used is circle head Gauhati, my lord. If my lord will kindly see
Is a inter-village
Inter-village.
customary?
yes, if my lord will kindly see page number 35, this is the letter by the ADC.
Now, what are you saying? Is that
Yes.
whether the Keba was an inter-village or the Keba village customary?
The initial one was a local village authority, my lord.
Village.
Village. So
Initial one means
the first Kaba.
first Keba. There are
yes, Your Honor.
two Keba.
Yes, you know. No, only one Kaba. Second one is the appeal. The first Kaba dated is 2nd July 2023. The first Kaba order, wherein it was held that the petitioner is the rightful owner of the plot of land.
Okay.
Against that, the respondent filed an appeal before the ADC, saying that I am not satisfied with the Kaba order. So after the appeal was filed, the ADC, if I may read, it's a small letter, My
What it has written?
my lord, it says to so and so circle head Gauhati, West Siang district, Kamba. Forwarding of Kava decision, sir. Enclose please find herewith a copy of Kava decision of land dispute case in between Sri so-and-so petitioner and Sri so-and-so, the respondent, which Kaba conducted on 2nd July 2023 under the head GB of so-and-so Dego Company, the village one. For your further necessary action with inter-village authorities, please. It was the direction by the ADC, forwarding of the Kaba decision by the ADC to the circle head Gaubura.
To the circle?
Head Gaubura.
Okay, the village customary court decided, and this decision was
Challenge.
forwarded
Yes, sir.
by the ADC to the inter-village customary court.
Yes, my lord. So after it was forwarded, Parwana was also issued, my lord. It is at page number 36, annexation 9.
Mhm.
Now, during the pendency of this appeal, my lord,
Mhm.
during the pendency of this appeal, the respondent, he filed for an RTI in the month of March 2024,
Hmm.
seeking information that how the LPC was issued to the petitioner.
Mhm.
Now, herein, my lord, we will see, we have annexed at annexure 15, page number 53, the note sheet by the ADC.
Hmm.
Herein, at
How
page,
did he get
the respondent got it through RTI, my lord.
note sheet also?
He got it through the RTI. My lord. It is part of the appeal, the application, so we have also annexed, my lord.
Okay.
So, in the second page, my lord, there is an observation. There is an observation by the ADC, my lord. If I may read, if I may.
What is that?
This again on 7/7/2023, Sri Jumge Kamki, the respondent, lodged an appeal petition challenge the local authority hearing decision for which was on 2nd July 2023. Hence, the matter was referred to the circle head Gaubura for taking up the issue in intermediary level. However, Sri so-and-so circle head Gaubura verbally informed that he was one of the signatory of the Kaba hearing conducted on 2nd/07/2022 under the empireship of head Gaubura Dego Kampi. So there is no point of retake of the matter since he had already signed the decision taken up on 2/7/2023 and he stands with the decision. Now, this is an observation, my lord. By the note, this is just a note. Observation by the ADC.
How it came to the civil court?
That is why, my lord. Basing on this only, he assumed that his appeal has been dismissed, rejected. Basing on this paragraph, wherein the circle head Gaubura has said that he is one of the signatory. So he's standing by his decision. Now, this is, as far the ADC's note sheet itself, it is just a verbal communication. It is reflected here. There is no written order. There is no written order till date that the
Appeal is against which order?
appeal is against the Kaba order of
Not
second.
this ADC's order.
No.
It was not treated as appeal then.
So
It was not treated as a dismissal as of the appeal, because had it been treated,
yes, my lord.
it would have been challenged. It was
Yes, my
not
lord.
challenged. So it was not treated as the order passed in the appeal.
Yes, my lord. However, my lord, if my lord will see the impugn order, there is an observation the learned court saying that although how it was arrived at is not known because there is no material in the record.
But then whatever may be,
Yes, my lord.
the respondent filed appeal before the civil judge.
Where that he, but my lord,
Under
our
which provision?
15(4), my lord.
Okay.
So
So what is your submission then?
my submission is that, my lord, the learned trial court, the civil judge, should not have entertained this appeal, my lord, because
Why?
his jurisdiction on this subject matter, my lord, is barred under the AP court, my lord, AP civil court, my lord.
Which one?
If I may, my lord.
15(4).
15(4), my lord.
Oh, read.
The amendment, my lord, which has, my lord, this, if I made 15(4), my lord, the proviso, my lord, provided that an appeal against the order of the inter-village territorial court or apex customary court shall lie before the court of civil judge, junior division, the Court of Civil Justice Senior Division, the Court of Additional District Judge, or the Courts of District Judge, as the case may be, as far the territorial and pecuniary jurisdiction. So now, my lord, in my understanding, my lord, the learned civil courts have been granted the authority and the jurisdiction to adjudicate upon an appeal from the from the decisions taken in the inter-village or the apex court, as it may be, my lord.
Not by the village
Not by the, because, my lord, if,
customary court.
yes, my lord, because,
But there is a provision in the AFR also.
yes, my lord,
AFR,
yes, my lord. But, my lord, the provision in the
it
AFR,
cannot be read in isolation.
yes, my lord.
What the AFR provides.
My lord, the AFR, in my understanding, my lord, there, if the AFR, it
The
provides,
amended one.
I mean, 2023 one,
Hmm.
it says, my lord, or
Read 23, 20.
the amendment to section 15(4), my lord. In the Arunachal Pradesh Civil Code Act, in section 15, in subsection 4, for the words, if agreed to the parties, the words if agreed to by the parties, or if the agreed party.
You are reading which one?
This amendment, my lord, this serial number 13, my lord.
Serial number 13.
Yes, my lord.
Just a minute. But let us just see the appeal provision. Appeal provision is provided under which?
In my understanding, my lord, the appeal provisions have been taken out from the AFR and confined to the AP Civil Code, my lord, under section 15.
Hmm?
The civil side,
Mhm.
it has been taken out
24.
of the AFR and confined to,
Appeal from
50.
village authorities.
my lord, it's reading with,
Come to the AFR.
yes, my lord, AFR.
Twenty-four.
Uh, My lord, herein also by the amendment of 2023,
Mhm.
it has been brought before the inter-village. More so, my lord.
Okay, so, okay, then read that substitution of section 24. Amendment 23.
Amendment 23, my lord.
Mhm. It will be serial number 9, substitution of section 24,
Mhm.
AFR amendment.
Yes, any party agree by the decision of village may appeal within 30 days before the inter-village territorial customary court or apex court.
Hmm.
My lord, herein I
Come
would,
down. Hmm. read.
herein I would like to make a submission, my lord.
Just read the proviso also.
Provide the proceeding in the village authority customary court, as the case may be, shall be recorded in writing in their respective vernacular, provided further that if agreed by the parties, or if the agreed party desires to appeal, as the
Mhm.
case may be, an appeal arising
Out of
village authority or
village
inter-village
authority
or apex customary court.
see
Yes.
village authority. It is village authority.
My lord, if I may kindly make one submission regarding that. My
Just read it.
Yes, ma'am.
Let us read it.
shall lie before the Court of Judicial Magistrate First Class, Court of Chief Judicial Magistrate, the Court of Additional Magistrate and Session Judge, or the Court of District. and
Okay,
Session.
as the case may be.
My lord,
As
it-
per the
yes,
jurisdiction.
herein I would like to make a submission, my lord,
Mhm.
that, my lord, this 24, it will govern the criminal side of the AFR, my lord. Because this comes under the criminal side, under the criminal heading of the AFR.
Mhm.
If my lord will see chapter 1 in general, and
Mm.
then this provide, chapter 2 is police. Because, my lord, the nomenclature used herein is judicial magistrate first class.
Mm.
My lord, I believe it signifies the criminal side of the law, my lord. Because in my understanding, my lord, the AP Civil Code has taken all the civil powers out of the AFR
Mm.
and confined them to the AP Civil Code under section 15(4), my lord.
Mm.
Therefore, my lord, if my lord will see chapter 5 evidence, and then this civil part, chapter 4 civil proceedings,
Mm.
herein the appeal provision, my lord,
Mm.
is only confined to that the decision of village authority may be appealed within 13 days. The person will need to inform. So in my understanding, my lord, that the civil side of the appellate authority should be governed by section 15(4) of the AP Civil Code. My lord.
Hmm.
So if AP Civil Code is seen, my lord, section 15, subsection 4, my lord, there is a specific hierarchy being provided therein that first it is the civil code, the village level, then the inter-village one.
But there also you see the proviso.
Yes, my lord.
Oh,
The section 4.
proviso, second proviso.
Provided the appeal against order of the inter-village territorial, my lord. That one, my lord.
Next, there is also, but then come down.
Provided for the Code of Civil Justice shall not set aside an appeal so filed mainly on technical ground or procedure lapses,
Mhm,
but in the interest of justice shall dispose of the same as may be deemed appropriate or proceed with the case deemed.
mhm.
My lord, in my humble submission, my lord, jurisdiction of subject matter, unlike my lord pecuniary or this territorial jurisdiction, these are
There you can, of course,
uh,
always
but
raise.
yes,
If you think, if the petitioner think that the civil justice senior division doesn't have the pecuniary jurisdiction,
yes, sir.
that can be raised before the, because that is subject to the pecuniary jurisdiction of the civil justice junior division, senior division, or the session, or the district court. That can always be raised before the appellate, first appellate court.
But my lord, my submission being that this is an issue of the learned civil court not having jurisdiction on the subject matter, my lord, because the section 15,
Hmm.
it specifically provides that the civil court will be sitting upon, and even as my lord had also adjudicated on this matter in Bomli Basar case also, my lord, therein my lord has also clarified that there is an hierarchy.
They are only the appellate.
Yes, my lord.
Hmm.
The civil court will sit as an appellate.
Only the issue was
Yes, sir.
whether the inter-village customary court
Hmm.
can entertain the complaint straight directly.
That being
That
that,
was the only issue.
yes, the issue being that, however, my lord had also clarified some things regarding the hierarchy as well, that how the village and how the statute
Hmm,
provides a special hierarchy that
Hmm.
first there is a civil court,
hmm.
then there is an inter-village or the apex court. Now these two form a different category.
Mhm.
Now the power exercised by these two cannot be taken by the civil court
Anyway,
directly.
we will hear the other other side also.
Yes, my lord. My lord, there was a small prayer, my lord.
Hmm,
My lord, as we have taken a plea of jurisdiction, my lord,
Hmm.
and already the Kava decision or passed
yeah,
the
the
year.
issues is of course the important issue you have raised, but then see staying. What is the last order?
My lord, will find the last order at page number
Oh,
last
to be listed for motion hearing. So there you can always take the plea of the raise the question of maintainability.
Yes, is there, but my lord,
Yeah.
I will have to again participate in a
Yeah,
trial because
you have to.
there is
Okay.
my lord, that is
Because this was only with regards to the application for condonation of delay, not yet admitted.
my lord, this
Appeal not yet admitted.
my lord, I believe it has been. If my lord will kindly see the last line of the order, my lord, the last paragraph of the order.
Let the present case be posted on so and so for motion hearing.
Oh no, my lord,
The
the page
motion
number
hearing to be listed.
136,
Hmm?
paragraph, page number 136, paragraph 46.
Hmm.
My lord, consequently, the civil appeal number 10 of 2024 shall be heard and adjudicated in accordance. That's why
Yes.
it was taken up. So my lord,
Yes, it will be taken up and it will be listed for motion only, wherein you'll get an opportunity to raise on the question of
My lord,
maintainability.
motion will come. My lord, our plea was that, my lord,
Let him
this,
appear.
the court will
No,
be-
you participate there.
if my lord, because my lord, I will again have to participate in the whole process.
No,
Now we are,
so the earlier,
yes, my lord.
this, what do you think, appeal is not the appeal. This was only disposal of the condonation application. and that lies with the civil judge senior division. The discretion he has utilized or the exercise, the jurisdiction, he exercised his discretionary whether to condone or not. The delay was condoned. That was under his discretionary, and then the questions comes that whether it is maintainable or not. That question you can always raise.
My lord, I will, in my humble submission, my lord,
We'll
we are
have to
submit,
give an opportunity to the other side.
yes, no,
Mm.
my lord, the other side can be heard and must be heard, my lord, but what our,
If we stay, then how it will be hard?
no, my lord, other
Maintainability.
party can be
How do
heard,
we
yes,
decide?
because my
Let them
lord,
decide.
this order in,
Let the
I-
court concerned decide.
yes, my lord, if my lord may kindly consider my one small
Mm.
prayer, my lord,
Mm.
our prayer was that this order, my lord, because the learned civil judge, my lord,
Mm.
you know, even in order to exercise his discretion under section 5,
Mm.
should have the jurisdiction to pass that order, my lord. If he
That has
does
not yet
have-
been decided.
my lord, only the part of the, I'm only,
Mm.
my lord, talking about this, if the
Assuming
order-
that it is appeal from the civil judge, appeal from the Kaba entertained
Yes.
and then condone the delay. Now it will be hard. You can always raise.
my lord, that is why we are saying that this is a gross, there is no jurisdiction by the learned court to, and that,
Not yet admitted. Once admitted, you come.
my lord,
Mm.
it's fixed on the 9th only, my lord. That is why we are saying, my lord, that if,
Participate. Let the civil judge pass order.
my lord, if
We'll
Your
issue
Honor,
notice.
notice,
Let them also participate before this court.
and my lord,
Because the things you are raising and there is a provision and see to decide is it will take time. We'll have to hear both the parties.
that's why, my lord, if it can be decided and if it is found that the order was wrong from the inception, then I will have to participate in 2 proceedings, my lord. That's why I'm just praying that, my lord, till now,
You participate there then in that case first.
my,
Let them decide. Come thereafter.
my lord,
It is
then,
too early for you then.
my lord, then our whole court challenge will go, because our challenge is that the whole proceeding is illegal because it cannot be instituted without a
Proceeding
learned-
not yet started.
My lord,
It is yet to start. It will be listed for motion,
yes, my lord,
motion hearing,
motion for-
wherein you have get an opportunity to raise question on the maintainability
at the motion stage,
of
my
the
lord,
appeal.
I believe
It has
will-
not yet started, Council.
my lord, it will only be for issue, notice usually issued, my lord. My lord, I'm reiterating.
No,
my-
you want this court to decide straight away here before the court, the first appellate court decide.
Because, my lord, my submission is that the appeal is still pending before the inter-village customary court. It has not been disposed of. Now, if it has not been disposed of, my lord,
That is different issue. That is different issue.
that is our ground therein, my lord, that it is not disposed.
Where have you stated that?
My lord, in our grounds, my lord, we have stated, taken up the plea, Your Honor.
Whether that was registered,
My lord, which one?
whether that appeal
Before the inter-village.
before the interview.
Yes, my lord, the Parwana was also issued. My lord will see the Parwana at page number 36, annexure 9, my lord. My lord, there is a pendency, there is a pending appeal going on, my lord, which has not been adjudicated. Page number, there were 2 Parwanas issued, my lord. Page number 36 and that page number 42, my lord. So, my lord, there is no, even, my lord, if we have also annexed the appeal memo, my lord. They have not enclosed the rejection order by the inter-village customary court, my lord, because the appeal is still pending, my lord. It had not been disposed of.
That is different ground. Let us see. Translated. Where is the name and address of the inter-village customary court who issued this Parwana?
My lord, will kindly, at page number 38, the bottom, my lord. Bango Kaba Dere at ADC complex, Kamba. Page number 36, type copy, my lord, the bottom part, my lord.
Where is the appeal?
Appeal.
Hmm.
Appeal.
Appeal before the inter-village customary court.
My lord, we will find that at page number 31, my lord. Although it was submitted before the ADC Khamba, my lord, the ADC Khamba had forwarded it.
Where is the counter, I think, eh? 31.
31, my lord. Yes, my lord.
Appeal was filed by
Appeal was filed a respondent hearing, my lord.
under section
He had filed it under section 9 of AP Civil Code, my lord.
9.
Nine.
His civil code is,
My lord, he's a layman, I believe, so.
Hmm?
the-
where is that? Where do we find that?
My lord, he's a layman, I believe, so he may have,
Hmm?
my lord, the section 9, my lord. Section 9 of the AP code only talks about sit or seal of a civil code, my lord. I believe he has wrongly quoted the provisions.
Hmm.
However, basing on this, my lord, the ADC has
Says,
forwarded.
it's on a civil code 2023. Where is the 2023?
Section 9.
Hmm?
No, my lord, section 9 of
You have the copy?
Lord, the 2023 amendment is of the AFR, my lord. I don't
It's
think,
AFR only.
I believe he has wrongly written.
AFR, that is,
I believe, my
Amendment
lord, he
20
has invoked the
23.
section 20.
this is AFR only.
Yes, my lord. I
Yeah.
believe he has wrongly invoked section. Section 9 is the substitution of section 24 of 8.
Hmm.
So, my lord, he has invoked the criminal side of the deal, my lord.
So you mean to say that there is a completely different proceedings for the criminal and the civil? And this substitution of 24 is not at all connected for the civil.
Yes, my lord, because the nomenclature used is judicial magistrate first class, because, my lord, and unlike in the AP civil code, my lord,
But the judicial magistrate first class is the civil justice junior division.
because the nomenclature used in the AP code is specifically civil.
I don't know why they have used, why not the alternative?
Yes, sir. And also, my lord, this section is outside the civil proceeding chapter, my lord, chapter 4.
See, as per their territorial and pecuniary jurisdiction. So in the criminal case, this also talks of the civil,
My lord,
cannot read in isolation.
that's because, my lord, the
Cannot,
heading of
as
the,
per their territorial and pecuniary jurisdiction, who shall not set aside an appeal, so file merely on technical ground or procedural lapses, but in the interest of justice.
Because my lord, the
We cannot probably read in isolation.
yes, my lord, but my lord may kindly consider the placement of this section. It is inside the criminal part of AFR, my lord, and the civil part is in the next chapter, my lord.
Still, certain things are to be clarified, of course.
Yes, ma'am.
That is true, but this cannot be read in isolation.
My lord, you also bring us to the issue that the one appeal is already pending before. Against the same order, one appeal is pending before the inter-village authority.
The consolidated one. And then this, see,
Because, my lord, this section 24 fine is placed in chapter 3, criminal proceedings, under criminal proceedings.
maybe. This covers, I think. This will cover. We need to properly have hearing on it and interpret. Where is the order
Pardon.
passed by the ADC?
ADC order is at, letter is at page number 35, my lord. On receipt of the appeal.
The inter-village customary court is a designated one then.
My lord, they have a this building for that Bango. This they are saying that.
That is there, but then
Oh.
the authority for the inter-village customary court.
My lord, they do
Because
conduct.
it appears that he particularly addressed to the one head GB.
Yes, my lord. He addressed him to initiate the proceeding, and then my lord, if my lord will see the Pravana at page number 38, there is my lord the type copy herein. The last paragraph of the first paragraph, last line of the first
Hmm.
paragraph. Hence, you are directed to attend a Bango level Kaba on dated 22/9/23. So the inter-village Kaba has been instituted.
Where in your petition you have stated that the appeal is still pending disposal.
My lord will kindly see. My lord. Para 15, my lord. Para 15. Second paragraph. Page number 11, my lord.
You raised before the first appellate court, saying that the appeal is still pending. This question you raised there.
My lord.
Let the appellate court decide.
That is one avenue, my lord, but
Mm.
we are hoping that this, if the impugn order by the learned trial court is set aside, will approach this pending one also, my lord, because that pending one has not been adjudicated, my lord. Now, if there is an error apparent on the face of the record, my lord, we are kindly praying that intervention may be there, my lord.
Because you have said that it was assumed that the appeal was rejected, dismissed. So then,
That part, my lord, that if that be the case, my lord, then the respondent, my lord, we have also annexed the memo of the appeal, my lord. There is no order annexed, my lord, and how can, and because, my lord, an order, a formal adjudication,
now because, and then thereafter says, however, in absence of the written order or formal adjudication by the Bango Keba, the appeal is still pending.
because nowadays, my lord, everything is in written, my lord. It cannot be assumed that something has been done, my lord, unless it's written, my lord.
This need to be raised there, because probably you had no occasion to raise this. Avail that occasion first, that opportunity first,
My lord,
let them pass order,
my lord, in the impugn order also,
and without passing any order,
yes, my lord.
merely on the basis of condemnation. Because at that, before the first appellate court, while at the time of hearing on the condemnation or delayed condemnation petition, you did not raise this question probably.
My lord, then,
Now you raise,
my lord,
and then
my lord,
raise the question of maintainability there.
my lord, he raises two questions.
Because let them peruse, let the appellate court peruse this and then decide.
My lord, we hoping for
Hmm.
that interference in,
Now, without raising before the concerned court and coming before here,
because my lord,
assuming that even if I raise also likely to pass this order, will be too early.
and that is so, but my lord, as demonstrated herein, my lord, this order,
No.
my lord, has
No,
been
no,
passed.
only filed, not yet heard.
uh,
So hearing is fixed.
yes, sir.
Avail that, raise there. Thereafter, you see, we will not dispose of this. We'll just issue notice. And as and when the order is passed, admitting, come again, challenge that by way of filing.
My lord, we have challenged all the civil
No,
criminal proceeding as well, the civil
No,
proceeding.
here you see, here you see, there is still, you have not yet raised the pertinent question, which according to you is, the appeal is still pending.
My lord,
Appeal, assuming and presuming that appeal was dismissed. And saying that that order having not been passed yet, it is assumed again that it is still pending.
my lord, even
One way you assume and presume that it's disposed of, but then saying again that although disposed, but then order not yet passed. So it is treated as pending.
that was a reason given.
So
by
that
the
was not
Supreme Court.
raised probably. Has it come?
My lord, we have also filed. My lord,
Anyway, Mr. Talu, what we'll do, we'll just issue notice. Okay? And then this is fixed on 9th.
yes, my lord.
After 9 you come, we'll fix after 9. Let them pass order and we'll, so thereafter only we'll pass order. What you'll pass after raising this? You raise the question of maintainability as well as the pendency and not disposal, not issuing the order, not passing the order on a appeal. Because now we are not clear whether appeal is pending. You are challenging what? The appeal from the appeal from the appeal
Yes, sir.
from the customary court doesn't lie before the civil judge, or the appeal from the intermediary court. Intermediary customary court is not lie before the does not lie before the civil judge, isn't it? Now that question still remain pending.
My lord, my
Yet to
question
be
is that
decided.
they should have challenged the inter-village order before the law,
Yes,
but they have not.
raise there. That's what I'm saying. You have still time.
That is there.
Hmm.
But
So I could understand that,
Yes, sir.
but now it's, since it is not decided here, you're also not clear about the disposal and then not raised. That has not yet been decided by the appellate court. It is too early. But then whatever may be, but we'll issue notice for the time being. Let them raise. Okay.
it might
Hard mistake.
kindly consider that.
Carlo. Lana counsel for that. Ajit Alonari counsel for the petitioner. This appeal, sorry, this petition, civil revision petition filed under section 115 of the, because you are raising a jurisdictional question.
That's
So
My lord,
that,
question.
you are also not clear
my lord,
against the appeal or against a customary order. Okay. Of the Code of Civil Procedure, read with Article 227 of the Constitution of India. That can, of course, always come. Directed against the order dated 16/7/2026, passed by the learned civil judge senior division Alo in it's a miscellaneous or interlocutory? It's a miscellaneous.
Miss case.
In miscellaneous case number 45/2024 of in civil appeal number 10, it has also been registered with
Yeah.
civil appeal number 10/2024, whereby the delay of whereby the London Civil Judge Senior Division has condoned the delay of 295 days in filing the connected civil appeal against, which order you said, against
Order dated 2nd July
against
2020.
order dated 2/7/2020. Which one?
At page number 26, my lord, annexure 6, 2nd July 2022.
Okay, 2/7/2023, passed by the, well, do we know the Keba, name of the Keba?
My lord, is it the village authority of Dego company? my lord.
Village Authority of
DEGO Dego
Dego
KMKI.
Kamki. Stop. Huh? Oh, 27. Okay, Dego Kamki village. Okay. Para. It is the Land Council for the petitioner submits that under section 5, subsection 4. Subsection 4 of section 15, of the Arunachal Pradesh Civil Court Act 2022. The Civil Judge Senior Division can only adjudicate an appeal against the order passed by the inter-village territorial court, the territorial customary court or apex customary court. But the does not have, cannot, you mean to say that you cannot,
Yes, sir. Because my lord, the condonation of the delay has been done for appealing against the village level Gauhati decision.
Okay. But cannot take up the matter decided by the village authority. Cannot entertain, cannot entertain the appeal file against a village authority nor condone the delay for filing appeal against a decision of the village authority. Stop. Para. What do you mean to say? He exercised beyond his
Jurisdiction.
jurisdiction.
Yes, ma'am. It is an illegality. The jurisdiction is not
Okay,
there.
and then, by by condoning by passing order in the, by condoning the delay in filing the connected civil appeal by the impugned order dated 2/7/2023, the learned civil judge has exceeded the jurisdiction not conferred upon it. Stop. Para. Issue notice. Call for the call for the scanned copy of the relevant record. Stop. Para. The petitioner shall take steps for service of notice upon the respondent by a speed post as well as by usual process within a week from today. Stop. Para. List the matter after 2 weeks. It is fixed on 9th. Then we will fix it on 14, 15, 16. Okay, 16. Okay.
My lord, a small prayer, my lord. Can it be that the prayer for interim can be considered on the next?
Okay. The interim prayer of the petitioner shall be considered on the next returnable date after hearing the parties. Okay.
But, my lord,
16, will it be done? The steps, will it be completed within 16?
by post,
We'll say 3 weeks.
my lord, it takes 1 week, 10 days only for the post to go. I believe it can be done.
It will be, because in any case, it will be more than 2 weeks.
Okay.
So we'll say 3 weeks. Okay, we do not know. Okay,
My lord, the matter 16th.
16.
So, my lord, I fix it on 16th.
Okay. You want to fix that?
Fix that will also do.
Okay.
Much of like.
Item number 2.
This one.
Yes.
This is a regular bail application in connection with Namsai PS case 51 of condition. At
Okay.
this stage, madam, notice may be issued and CD may be called for.
Okay. What have you filed bail? Moved any bail application before the trial court?
Yes, ma'am.
Rejected.
For the special judge. And the PS. Send
Who-
PS.
Okay, where do we find?
It is rejected.
Rejected.
Regarding antecedent, there is no any disclosure, man.
No disclosure.
Yes. On
And probably that is statutory.
Yes.
Made it a statutory. You have to disclose. It is okay. Where is that paragraph?
But, in para 33, they have disclosed, they have pleaded that the petitioner
No,
has
no,
not
no.
filed any other petition before the Supreme Court or any other court of law for same cause. That is regarding the first part. The second part is regarding, my lord, the antecedent.
Antecedent of the.
That part
That
is-
you have to, I think. It is okay. That is compulsory, means statutory, made it statutory. You have to disclose that. Then you have to file it again Monday. Same thing, just one.
Yes, my lord.
Okay, or any documents you want, because it's from them side. Okay, Mr. So, okay, Lana counsel for the petitioner. Seek permission to withdraw this bail application. Some is that there is we will not say that, okay. Seek permission to withdraw this bail application with liberty to file afresh after making necessary correction. Sub the prayer is allowed. This bail application is dismissed as withdrawn with liberty as prayed for. Okay.
Deeply obliged, my lord.
Item number 3,
Please, your lordship.
Yes,
Lordship, this is a regular bail application. My bail application before the district execution court was rejected.
Hmm.
That order I have annexed, lordship.
you have made a disclosure.
Disclosure, yes, lordship. I have made that disclosure. Lordship will
Mhm.
find that paragraph 45 regarding the no criminal antecedent. Bail rejection order, lordship, paragraph 17 is the
When it was
annexure,
page,
annexure 12,
page bail rejection order,
page 90, lordship, 90. Annexure 12,
page 19,
90, 90,
90.
correct, lordship.
Okay.
Ground of rejection, lordship, page 91,
Hmm.
paragraph 7.
Hmm.
I have carefully perused the case diary and has observed that there is a sufficient criminal antecedent against the accused person. This further observed that the plea that the accused used to reside in the barrack is found to be false. Plea, as the case diary reveals, that the accused was allotted to a single room as he denied to stay with other staffs in the barrack. It is further observed that the victim in present case, being vulnerable witness to be, cannot negate the submission of the alert PP, that in the event of releasing of the accused, there is very.
What is the stage of the?
Lordship, I have annexed that page 98, Lordship. CC has been framed against me under section 60 of POCSO Act. And
Annex
Okay.
this one series.
How many FIR are there?
My lord, there exist two prior FIRs before this FIR was lodged against the accused applicant.
Earlier also lodged FIR by
Mhm.
whom? Same person.
No, my lord. The previous FIR which exists was lodged by the alleged accused himself and his wife. My
Hmm?
lord.
Accused person's wife.
Yes, my lord.
Okay,
And
he's a naughty
alleged-
boy.
No, my lord. Actually, there were prior FIRs which were lodged against the people, the complainants or the relatives of the complainants of the FIR dated 18/08/2026, which is annexed as one series. my
Okay,
lord.
the allegations, what was the allegation earlier? Have you annexed the earlier,
Yes,
the
my
previous
lord.
FIR also? Where,
Yes, my
where do we find that?
My lord, it is annexed as 3 series,
3 series.
paged as 24, my lords.
Okay. Have you annexed the type copy? Okay.
Yes, my lord.
This was filed by, page 26 is filed by
The accused alleged the applicant himself, my lord.
accused.
Yes, my lord.
He himself, against whom?
Against the relatives of the complainants who have lodged a FIR against him, my lord.
This was 16/8.
Yes, my lord. 16/08/2026.
Okay.
My lord, there is also one more FIR complainant which has been filed by the accused applicant's wife, my lord, where she has also mentioned that she had been attacked by sharp weapon which had made severe injuries
By whom?
by the relatives of the complainants of the FIR of 1808, which is annexed as 1 series, my lord.
Okay.
My lord, the matter is personal, my lord. In the village level, these people know each other, my lord. They are in relation also.
Hmm.
Thereby, the complainants have filed this FIR just to harass the alleged accused, the applicant of this instant bail application, my lord. But the matter of the fact is that in the annexed as series number 4, my lord, whereby we can see that the applicant's wife had been attacked and she had received severe injuries, my lord.
Who?
The applicant's wife, my lord. And the council has also annexed the copies of the medical slips, my lord, in the annexed as annexure number 5 series, my lord, which is paged as 30, my lord.
Thirty is what?
Medical slips of the alleged accused wife's injuries, my lord.
Injury, this is injury caused to the wife of the accused.
Medical.
Hmm? Injury caused to whom?
My alleged accused wife, my lord.
Okay. Caused by whom?
By the son of the complainant of the FIR lodged dated
Okay.
1808-2026, my lord.
So
One named Raju Soja, my lord.
you are from the same village,
Yes, my lord.
known to each other.
Yes, my lord.
So that is why keep on fighting with each other.
Ma'am, my lord, it seems that Hmm.
Page 23. There is, I think, something which the learned court has made an observation. Page 23, come to page 23. Second paragraph. Kindly read. In the circumstances.
in the circumstances above, applicant accused does not deserve for anticipatory bail.
Hmm.
Accordingly, prayer in this ABA is rejected with a direction to the applicant accused to surrender himself before the IO immediately in the interest of the fair investigation.
Okay, then what happened? Have you surrendered?
My lord, the alleged accused, the applicant, is ready to cooperate with the.
No, the direction is to surrender
Yes, my lord.
and then cooperate. Have you surrendered?
He has, my lord, he has been in the medical for checkup of his wife, my lord.
Miss Jenny,
Your Lordship,
just this direction.
Your Lordship, first of all, the
If he is not
with
ready.
regard, no, with regard to the particular sentence of antecedents and any bail pending is not in this petition, Your Lordship.
Is it?
Yes,
Antecedent not given.
not given.
Where have you stated that there is no other criminal case pending against you before any other court, police station? Have you stated
Mm,
criminal antecedent of the accused applicant?
no, my lord.
There is a notification wherein you have, it is provided that you have to disclose if there is any other case pending against you,
Yes, my lord.
you have to disclose.
Yes, my lord.
Then you have seen the earlier one withdrawn, petition. The earlier one withdrawn because antecedent not disclosed.
Yes, my lord.
I think you have to do the same. Withdraw and file afresh. Disclose if there is any case pending against this accused person. You have to disclose that. If there is no case, then you have to state that there is no any other case pending against the accused petitioner before any other police station or court. No? So that is mandatory.
Yes, my lord.
So you have to disclose. Miss Jenny, is there? So this observation probably, if he is not ready, probably direction to surrender may not be correct one. Unless he is ready.
Yes, Your Lordship. Your Lordship, the direction was given while rejecting his bail order. Your Lordship, he has approached the court for granting him a bail, and therefore the court made the observation that you're not eligible for bail, and therefore you better surrender. That's what perhaps that's what my interpretation.
There is also counter complaint. There is also counter complaint.
Yes, Your Lordship, the counter complaints, Your Lordship will see, it has,
And that complaint was prior to the present complaint.
it has not been registered, Your Lordship will see.
Has been registered.
One has been given for inquiry
Huh.
and one has not been registered, the wife one. Also, Your Lordship will see the medical document that they have shown is after 12 to 16 days later, these medical reports are. Incident as per the wife has happened on 9.
Anyway, see, so you better withdraw and file afresh. And then
Yes, ma'am.
you have heard she has pointed out something.
Yes, my lord. My lord, the council simply submits that, my lord, kindly grant pre-arrest bail till
It will be dismissed on withdrawn. So there will be no
Withdrawn.
pre-arrest at the moment.
withdrawn. my lord,
Okay.
withdrawn.
Miss
Tana Opus.
Land Counsel for the petitioner. Seek at this stage, seek permission to withdraw this bail application with liberty to file afresh after making necessary correction. Staff, Miss Cheney has no objection. Miss Cheney Land PP has no objection. Accordingly, this bail application is dismissed as withdrawn with liberty granted to the petitioner to file afresh after making necessary correction. Okay.
Much obliged.
Item number 5.
Yes.
Lordship, this is an anticipatory bail application under 483 of UNN.
Yes.
The ground for the bail is this case is page number, kindly see the FIR. FIR is page number 13.
Yes.
Kindly see the page number 13. This is completely a case of civil nature.
Civil nature.
Yes. This complainant
So when the FIR was filed,
FIR is kindly see 20 July 2026.
okay, July.
20 July 2026.
How it is civil and how they have
Kindly see.
made it as a criminal.
We can understand from the FIR. It is how it is civil.
Hmm.
Kindly see in the second line after sir, during the year 2010, the above mentioned active person.
Where?
Page number 13, FIR copy. I am reading the FIR.
Okay.
We say the complainant is a one provider, a powerful not politician, contractor.
Hmm.
And
Contractor.
he says, represented the poses, that accused person poses substantial political, bureaucratic, and official.
Who possess?
He is alleging me.
Okay. That you are possessing power. But
Back to back work or subcontract work.
okay, but you don't have power.
Gauhati Ring Road. I am from Gauhati. Ring Road. This project is going on there.
So what is your submission? You don't have a power. He says that you have a power, and with that power, you influenced.
I am also a contractor. I am seeking. I am a businessman. Basically. I am seeking work, and since I am a businessman.
Who he is? Who he is?
We
Who you are otherwise? A government officer?
no. I am
Okay.
a just businessman. I have disclosed here. I am a business.
There is some agreement.
Interested.
There is some agreement between you.
Yes. Kindly see.
Reduced into writing.
He himself said, kindly see, believing his representation to be genuine and acting in good faith, I have entered an agreement MOU.
Where is the agreement?
He has said, I have not been given.
Oh, what you, what,
The complaint, kindly see the complainant.
Hmm.
Complainant.
no, he
said-
says there is agreement.
he
What do
said-
you say?
said-
Whether the agreement was entered between the party executed?
Yes,
There is an agreement.
yes. He said there is a, yes, agreement. Admittedly, there is an agreement.
Okay.
There is the exchange of security set as well.
Hmm.
We have access the security set.
Hmm.
We are seeking work. We are procurement of work, some work for execution of some work at the Ring Road Gauhati project. Gauhati Ring Road project under the NHAI, National Highway Authority of India.
Hmm.
We are seeking work. So to obtain this work order, we were having agreement for back-to-back work.
Hmm.
That was our agreement. And accordingly, on the basis of our agreement, he has this complainant has released 1,24,71,000 rupees.
Hmm.
I am not directly connected, but I'm indirectly connected since it is a
Release and paid to whom?
demo. It is, it has been
Paid to whom?
paid to my team.
Your team means you are also having a farm.
I'm also part of the team. That is why.
What team?
This business work.
Okay.
Yes.
What is the name of the team?
Name of the team, exactly, it is not the team, it is under the agreement, MOU. That is why. I am a businessman, first of all.
No, whom,
May-
whom the informant has released this
may-
money,
may-
paid this money
May I submit?
to farm or to you or to anyone? Huh?
Exactly, I cannot say because this my senior has sent this copy of this after notarized copy has been sent.
Hmm.
This petition, bail petition has been sent.
Okay.
But exactly, I cannot say whom the money has been released. This honorable court is asking
Mhm.
whom the money 1 lakh and 1 crore 24 lakhs plus money has been
Mhm.
delivered.
Mhm.
But admittedly, I am reading over the copy of the complaint.
Mhm.
As per the complaint, what
Hmm.
I have understood is there is an agreement. In
Hmm.
agreement, there was a promise to back work for
Hmm.
subcontract work, for which agreement was the work was to be obtained from National Highway Authority of India by this agreeing party. Then MOU was drawn on 30 August 2025. As per the third paragraph, he said,
30 October.
yes, 30 of October 2025. Again, he said, he has exact date is not written, but we have on face value, we are accepting that money might have been released. And 1 crore 24 lakh 71,000 has been released. And for that, we have exchanged security check. He has said, the complainant has said in the last paragraph, kindly see, that further strengthen my confidence, the accused person handed over a security check, assuring that in the event the promised work was not secured, if the promised work is not secured, the entire amount would be refunded. That is our agreement. It is a fact too. There is an agreement. If there is a failure in obtaining the work, the entire amount will be refunded. Which implies, what implies from this language? It is not the case that no effort is being made for obtaining all those work. Activities is going on, under active participation is going on there. But what he say, even after calling my telephone call, he's not picking my call. He say, the complainant say, it is a serious case of cheating. Where even if the whole FIR is taken into its face value, it is a case of breach of contract. It cannot be an inducement. There is nothing in such allegation of inducement.
The paper of supply order,
This on-
the supply order, etc. brought by you
Even
was false, fabricated, and forged.
Yes, that is why on prima facie, it shows that there is an agreement. As per the agreement, the accused person is not.
No,
working-
see, after
working with,
entering agreement,
And there is a.
see,
for
just,
collective purpose.
1 minute. Can you give me 1 minute? Okay. Then this allegation is that those papers,
Yes.
which, on the basis of which the agreement was entered,
Yes.
came out to be the false, fabricated, and forged. Then
That is the allegation, that is why.
that is the allegation.
That
Mm.
that is the allegation. I
Yes,
am
but then,
saying-
yes, just a minute.
I am,
Yes. So it appears there is some transaction.
Lordship, if
We
Lordship-
can call for the case diary.
Yes, very well.
Okay. Heard Mr. Tapak, then counsel for the petitioner. Also heard Ms. El Hage, then additional PP for the state. Staff para. By filing this application under section 482 Bharatiya Nagrik Suraksha Sanhita 2023, the petitioner is seeking pre-arrest bail in connection with Nirjuli Police Station case number 58/2026 under section 3184. What is this 318?
You are
Four.
right, Lordship, this is criminal breach of trust, Lordship.
3165. What is 3165?
Cheating, Lordship.
Hmm?
Cheating.
Cheating. Okay, BNS. Hmm.
it was 420.
Okay.
and now
So,
41 is criminal breach of trust.
hmm.
Criminal breach of trust, not affected by 3183. Thinking that allegation is level again.
Yeah, actually, both are affected, Lordship. 318 is actually affected, Lordship, because they themselves projected as a Lordship, other person, Lordship, different person. So that is also affected, Lordship.
I have been.
The prosecution case aids could be seen from the copy of the FIR. Is that there is an all these regarding offensive conspiracy also.
Says that there is a conspiracy. Allegation is regular. There is nothing except.
Common intent should be.
An allegation against the applicant for criminal conspiracy, cheating, mental harassment, life threatening, criminal breach of trust, forgery. It must be impersonation, and impersonation. And the money also straight away directly not to the, it appears that the accused. So, based on, just a minute, based on the above FIR lodged by one Mr. Loma Golo, proprietor, GB Enterprises. The aforesaid Nirjuli Police Station case has been registered.
Lordship, the notice already been served to appear.
Stop. 30 days. The Learned counsel for the petitioner submitted the transaction, if any, between the informant and the applicant in connection with what?
MOU. On the basis of MOU, we have drawn MOU.
For what? For what?
For obtaining MOU was for obtaining some work.
Okay, for obtaining some work. For obtaining what work?
We wrote going on to acquire. What
Obtaining obtaining work order for construction of ring road in Assam
at what
at Gauhati,
payment
for which the applicant for which memorandum of understanding were executed between the informant and the applicant, and as such the claim, if any, is any against the against the applicant is civil in nature. Stop. However, after registration of the case, the police has issued notice against the applicant under section 35(3) of BNSS, requiring his attendance in connection with the aforesaid police station case. Hence, there is an apprehension, every apprehension that he may be arrested in connection with the aforesaid police station case. Stop. The learned counsel for the petitioner submits that the applicant submits that the applicant is ready and willing to cooperate with the investigation and shall abide by. Where is the have you disclosed the antecedent?
I was not aware of that notice.
Okay, now you are aware. Now withdraw. Now withdraw.
Yes. That is why.
No, that is mandatory. Just show him the notification. Distribute the notification. I was ready to grant.
That part is
Now I remember, and she also did not point out, but that is compulsory. We cannot spare anyone. Although I feel for you because it was on the halfway, but then what can I do? It has to be treated. It should be equally. So come Monday.
or
No, amendment not possible. File fresh. Okay.
make that appropriate.
Okay. Mr. Mr. Pitapa, Learned counsel for the petitioner. Seek permission to withdraw this bail application with liberty to file afresh after making necessary correction. Staff. Ms. L. Hage, Learned Addition PP has no objection. According this bail application is dismissed as withdrawn with liberty is prayed for. Okay. Don't forget. इसको बांट दो सबको, notify कर दो, because we can't skip the statutory one.
Mandatory actually.
Mandatory. Okay. We'll come back after 3 minutes. Yes.
Item number 6.
Yes.
My lord, on the last occasion, TCR was called for, my lord.
Mhm.
And in the TCR, my lord, the MLC report of the victims.
Hey, have you annexed the deposition of the victim?
No, my lord, no, my lord. That is not in question, my lord. The question in the.
No. Just have you annexed? Otherwise,
No, my lord, no, my lord.
she was examined already.
She has been
Is
examined,
it
my
there
lord.
in the record?
It's not there,
Okay.
Your
It's
Lordship.
not there.
not there, my
We
lord.
had in fact called the record of the MLC report as well as the statement of the doctor who was examined, Your Lordship.
Okay, doctor. So
Because,
doctor is there.
yes.
Only
it's not,
doctor.
it's not there. It has been annexed in the petition, Your Lordship. It's not on the
Doctors.
record. Yes.
Where do we
Page
find?
number 37.
Whether doctor was examined or has the doctor says something about the examination or his record regarding the history.
No, my lord. This was, my lord, this was not allowed, my lord. This was objected to by the presiding officer, my lord, on the ground that it was not relevant. It was objected.
No, it's written in page number 38, Your Lordship.
Page number 38, my lord.
That question was in fact put up, Your Lordship. If you
Okay, where?
Your Lordship will see the, from below, Your Lordship will see the cross-examination, the last cross-examination, the first paragraph, last part, I do not have personal knowledge about the offense except narrated by the victims, Your Lordship.
See, he has clearly said. What more you want?
My lord.
More than this?
In fact,
My lord.
if Your Lordship will see the MLC report, Your Lordship, there is a column whereby the the narrator.
Yes, that is there. So except
That's what they are telling, that she has not revealed something that was told to them. That's a exhibited one. In the final argument or any other.
this is exhibited one.
Yes.
And doctor says, I do not know. What do you want to extract from him now?
Yes, my lord.
I do not know, he says.
My lord, for that, my lord, kindly come to para 9 of the petition, my lord. Para 9, my lord. Paragraph 14, my lord.
Why?
My lord, in this, my lord, I have shown, my lord, two questions were asked, my lord, primarily.
Para?
9, page 9, para 14, my lord. Two questions were put forth by the learned defense counsel, my lord, during the cross-examination, my lord. And the two questions were, my lord, is it true that victim has, question number 1, my lord, is it true that victims has categorically informed you that they were not sexually assaulted at Gauhati? To which the PW16 has replied, no, the victim was sexually assaulted at Gauhati. Now, this is contradictory.
Okay.
Item number 8.
Please, my lord.
Yes.
My lord, in this matter, I have agreed by the dismissal of my CR case by the learned trial court. And the trial court, without examining the complainant and his witnesses, which is mandatory under provision of section 223 BNSS, my lord.
Corresponding 200.
200, yes,
CRPC.
corresponding 200 of CRPC, my lord.
Proceed, my lord. What my humble submission would be, my lord, the notice was issued and it was returned unserved. Now, my lord, this is a criminal revision petition, my lord, where the person agree, if person in any, how if is agreed by the order by this court, then he must be impleaded or he must be given an opportunity.
Not impleaded.
He's impleaded. Notice has been served, my lord. What my humble prayer would be, my lord, make for ends of justice, may my lord engage one amicus or legal aid counsel to represent the my lord
Okay.
victim.
Just a minute.
Yes, my lord. Otherwise, my lord, they have a
This
good
is
case, no
the
doubt, my
my
lord.
lord. Private respondent.
Private respondent, my lord.
And this is just, my lord, a single case of cheating, unlike those rape and POCSO case. It's not necessary to provide the income.
It's a complaint case, my lord.
No, complaint case.
Complaint
Then,
case.
Yes, my lord.
But
So-
since you have also impleaded,
Just for ends of justice, my lord, the legal aid counsel was to represent the this one number two, my lord, or amicus, my lord.
Remand. To recipient the cruiser. Has it come on record that notice was received?
Office note is there, my lord. In office note, my lord. Yes, and yes. Okay. It will be under the complaint. Let's be nice.
My lord, very small issue, my lord. Maybe. Okay, so we'll appoint one. Okay, hard, Mr. Dilaji Line Counsel for the petitioner. Also hard, Mr. Pietelane additional PP for the state. Stop there. It is noticed that the notice has been duly received by the private respondent number 2. However, no one appears on behalf of the respondent. It appears that the respondent is unable to arrange to engage private counsel to represent her case, her or his, his case,
My lord.
his case. So, in view of the above, this court deem it appropriate to appoint one legal aid counsel to represent the private respondent number 2 staff. Accordingly, who, anyone?
Let
volunteer?
me engage, my lord, one legal aid counsel present.
Namely,
Name, me, Emma, Lordship, serial number 28.
28.
Yes, Lordship.
My guess. Legal aid counsel. Hmm. 28, yes. Mr. Mipe Ate. From the panel of legal aid counsel is appointed as the legal aid counsel to represent the private respondent number 2. Staff, the petitioner shall furnish a copy of the criminal, it's a revision. Criminal revision.
Yes, my lord.
Yes,
Criminal
Petition to the learned legal aid counsel for the respondent number 2 during the course of the days. Okay? You prepare
Yes, Lordship.
and then
And same on same issue, my lord. The one matter is fixed on second, my lord. And same issue.
okay,
So
then we'll fix.
both the matter taken up on second. my lord.
Okay, as requested. Come prepare on that there. Okay. On the request of the parties, list the matter again. List the matter on second.
Yes, my lord. Deeply aware.
Matter number 12.
Yes. None appeared.
The council was here, Your Lordship.
Council is there. Yes.
This is a criminal appeal.
Criminal appeal.
Passing.
Hmm?
Yes,
Criminal appeal? It's not a criminal appeal. Criminal petition only.
sorry.
Quashing petition.
Yes. Passing petition. Challenging the FIR
Okay.
filed before the
15/5/2026. 316. What is 316?
that is corporate
3165.
criminal breach of trust. Criminal breach of trust.
3184.
You think
61.
that is
Punishment for criminal. Okay.
that.
Just a minute, huh? Okay, yes, sir. Yes, where is the FIR? What is the allegation?
The allegation is that the FIR was filed by one C.
Page. Okay, 23. Complaint under such and such, huh?
To the officer in the Economic Police Station.
Okay, okay, no need to read that.
Complaint under section 813, 316, and 61 of NS 2023 and other applicable provisions regarding 15 criminal breach of trust and conspiracy. Respected sir, I, Sri Devta Singh, presently residing in Suriname, submit this complaint for registration of the fire against the following case. The present petitioner before this honorable court. Proprietor of Genge Construction, Anuj Bhadwar, proprietor of MS AMW, AMB Infra and Engineering, and other person found involved during the investigation. Fact of the case. That Sri Hatatu, being the proprietor of a firm, was likely to be awarded a project work service for induction of certain technical units at AF station, Tejpur, on engineering, procurement, and construction EPC mode. That Sri Anuj Bhadwaj, acting on behalf of Mr. Hatatu, approached Sri Takam Sanjay, proprietor of MS Don Tani Enterprise, to arrange for fund for performance guarantee for execution of the said project and transfer the work under bag-to-bag structure to MS Dhoni Tani Enterprise or share 10% profit from the project. That on 12th August 2025, Sri Takam Sanjay informed me, the informant, and inquired about the possibilities to manage the fund and take up the project. Subsequently, on 13th August 2025, Anuj Bhadwaj, Takam Sanjay, and myself had a meeting and discussed to manage the fund and take up the work on back-to-back basis from MS Genge Construction to MS Dhoni Tani Enterprise. That after a meeting on 13 August 2025, I involved my wife, Srimati
Dado Renu or Dado Renu Kyoda, proprietor of so and so, to be the partner in the business with MS Don Tani Enterprise, and consequently the project will be transferred from Doni Tani Enterprise to MSIM developer on a back-to-back for effective control and efficient management, and also both agreed and consented that I self took after the project as a project head or project manager. That based on the such representation, I along with my wife Srimati Dado Renu, alias so and so, arranged rupees 3 crore from a local market by 20th August 2025 by prevailing interest rate in a good faith and with legitimate expectation of participation in the project. That on 21 August 2025, rupees 3 crore has been transferred from the account of MSIM developer ICIC Bank Doimuk to the account of MS Kenge Construction for Maharashtra branch, Maharashtra Bank Itanagar. That after many attempts with serious efforts and prolonged waiting, Sri Hatatu, proprietor Kenge Construction Co. executed an agreement with Sri Takam Sanjay, proprietor MS Doni Tani Enterprise on 16 October 2025. And acting in the good faith, I started working as a project manager and performed my responsibility diligently. That suddenly and without any prior notice, Sri Hatatu unilaterally revoked the agreement with Takam Sanjay and automatically break the further agreement between MS Donitani Enterprise, proprietor Takam Sanjay, and IM developer, proprietor Kado Renu, failed to return the invested money, time, energy, and service offered for the project. Eliminate me and my wife from the project, who bring life to the project from a dead end by managing heavy portion of fund for performance bank guarantee, in short, bank guarantee of the span of 4 days, risk many movable or immovable property of my family as well. That subsequently it came to the light that Hatatu, proprietor, Kenge Construction, and Anuj Bhardwaj had already engaged into a separate back-to-back agreement for the same project on 19 August 2025, 2 days prior to the transfer of fund from the account of IM developer proprietor Srimati Dado Renu to the account of MS Kenge Construction. That the fact was intentionally concealed for us, me and my wife. That Sri Anuj Bhardwaj, acting as a witness in the agreement between Takam Sanjay on 16 October 2025, despite the prior knowledge of the pre-existing agreement between Hatatu, proprietor MS Kenge Construction, and Anuj Bhardwaj, proprietor of IM developer, dated 19 August 2025, indicating collusion and conspiracy. The act of the accused person clearly constitute cheating, that is 318 of BNS, criminal breach of trust, criminal conspiracy. This is the FIR. Lordship, this FIR was filed on 15 May 2025. May I take, Lordship, to page number 105. Next. Lordship, here the main crucial point is that on 15 May 2026, this present FIR has been filed, but prior to that, that is on 4 March 2026, page number 105 of my this petition, the parties, the complainant, Yoda Sanjay, and the named accused person in this case, they have mutually agreed and settled this matter. Lordship, it is very pertinent to mention that this is a case where the informant complainant is trying to give a color
of a criminal nature in a purely civil dispute, which is a contractual in nature. The dispute, even before the filing of the FIR, the dispute has been amicably resolved. In fact, by concealing that the resolved settled matter, they have filed this present FIR only with a malicious intention to harass the petitioner, accused applicant. Lordship, I am reading my submission is substantiated by this document. Lordship, page number 104, the typed copy is 105. 104 is an agreement between Hatatu, that is the petitioner accused, and Dado Renu, proprietor of IM developer. It is a matter in the matter of work service for induction of certain technical units at AF station on engineering, procurement, and construction mode. The following condition has been arrived and concluded that the total amount calculated as on 4th March 2026 is that principal amount 3 lakhs, interest amount rupees 90 lakhs as on date is rupees 3 lakhs 3 crore 90,000. Sri Hatatu, proprietor Kenge Construction Company, will pay rupees 1 crore 60,000, 60 lakhs only on 5th March 2026, and the balance amount on or before 31 March 2026 to MS to Srimati Dado Renu, proprietor of MSIM developer. If condition is stated in serial number 1 and 2 is failed to executed by the proprietor, MS Kenge Construction Company, then total loan amount shall be recalculated as in an amount of rupees 2 crore 30 lakhs plus interest, and new total shall be changed into interest of 5% per month. If he pays rupees 1 crore 60 lakhs to MSIM developer, if he pays rupees 1 crore 60 lakhs is not paid to MS Kenge Construction Co. IM developer, then the further necessary instruction shall be given to the parties and all other witnesses. The mutual settlement agreement has been made by both the parties without any coercion, without any ill intention, and with honest intention in presence of the witnesses as mentioned below. After execution of this agreement, Lordship, the proposed amount was repaid back after registration of this case, repaid back, and including an excess amount of rupees 90 lakhs was also paid to the complainant. Lordship, as such, here in this case, the present case has been initiated by the informant just to harass the accused person. So surprisingly, when for the first time the accused petitioner has received a notice from the Itanagar police station with regards to this case, then suddenly on 6/6/2026, that is page number 26, Lordship, Annexure 3. Page number 26, Annexure 3, Lordship. When the police issued notice to the accused petitioner to appear before the investigating officer, the accused person appeared, although there is no provision for filing clarification or written statement in a criminal case. But in order to place my grievances before the police, in order to cooperate my investigation before the police with documents, I have given a clarification letter, Lordship, wherein also I have given all the vouchers, bank deposits, regarding the repayment of money and all those agreements which we have executed between both the parties, that is the complainant and accused person. On 6/6/2026, page number 26, I have appeared before the officer in charge upon issue of receipt of notice. I have given my clarification. I have stated in my clarification letter that it is agreed that there was, I am reading my clarification letter, page number 26. With due respect, I, Sri Hatatu, proprietor so and so, submit the written statement and clarification in connection with FIR. The Chief Engineer, Air Force, Shillong Military Engineering Service, MES, Elephant Fall, Camp Shillong, issued a tender notice, that is work for service induction of certain technical units at Air Force Station Tejpur on EPC mode. Tender number so and so.
It's long, I think.
Yes, yes. I have explained everything in details, along with the vouchers of repayment.
So you also appeared before the police?
Yes, yes.
What happened then?
Yes, I appeared.
What happened thereafter?
Thereafter, the police is doing the investigation, and at present.
You have already given your statement,
Yes, yes, yes. I have given my statement.
written statement
Yes,
also.
yes, yes. I have given my statement, and the regarding the.
You were you arrested,
Yes, formally arrested, but.
formally arrested and
yes,
released?
Since the.
Released.
Yes, yes. Formally
Okay,
arrested.
what is the stage of the investigation?
Stage
Your
of
Lordship,
investigation.
as per Your Lordship, the last direction, Your Lordship, we have got a WT message.
Hmm.
Your Lordship has called for the updated CD, Your Lordship.
Hmm.
There is the CD which has been submitted before this court
Hmm.
has been submitted in the trial court, Your Lordship, and the file is there. However, Your Lordship, I have just given a small WT message. It will be.
Okay, what it says?
It says that even the IO is not in the station, Your Lordship, and there is a request that there is no investigation so and so in Delhi with another case. As such, he is unable to update, and the file is still in the trial court, Your Lordship. So there is no update as such. Whatever the CD that I have produced before Your Lordship is the only update available, Your Lordship.
Okay, since he's out of station, he's unable to update the case diary.
Whatever the case that I have produced before Your Lordship today is the latest updated, Your Lordship. If Your Lordship see the statement of, if I may submit, Your Lordship.
Just a minute, when the FIR was lodged? This was
On
Okay, May.
21 May 26, Your Lordship.
Mhm. How many person has been made accused here? Only one.
Only one, Your Lordship. Oh, yes, two, Your Lordship.
Two.
Anuj Padwa.
Anuj.
Okay.
Bharadwaj. There are two. Yeah, Anuj Bharadwaj का था ना? Oh, ये clarification.
So of July. 1 month back.
Yes, Your Lord.
So since he's out of the station, no updated CD.
No, like there is no updated to the investigation. Whatever the CD has been produced, it till date, that's the latest update, Your Lordship. No
28th
further.
July.
Yes, Your Lordship.
Now,
Because the CD was with us, Your Lordship, since the previous, during the previous proceeding, there was no call for the updated CD, Your Lordship. So we had never called for the updated CD. It was
Okay.
only on the last occasion on my request, Your Lordship. Because the case was pending and the parties had been taking time continuously, therefore,
so what do we do now?
Your Lordship can take up this matter because there is there is also a prayer saying
Is
that
there any
it is the-
progress in the investigation thereafter?
nothing as such. Therefore, I was coming to that, Your Lordship. If Your Lordship will see at page number 3 of the CD, Your Lordship, that's the statement of the wife of the complainant, who is also the proprietor of the
I am
developer, who is to which the work was given and against which these allegation of the transaction of the money was done, Your Lordship.
Accused was also examined
Yes, it's her statement. It has page number 3.
and
Your
then
Lordship.
the complainant also examined.
Yes, Your Lordship.
Then it is ready for filing charge sheet.
Since Your Lordship, it's nothing as such has been stated in the WT message, Your Lordship. I can't comment on that, Your Lordship. Because there is nothing to the exact status report, Your Lordship.
Okay.
I'll just pointing out because
So-
there is an opinion being written by the IO prior to he left for the another case, an absconding case in Delhi, has been in Delhi for a very long time, Lordship. Lordship will come to page number 3 of the CD, Lordship.
Okay.
That is the statement given by the wife of the present accused, present complainant, who is the real proprietor of the IM developer, Your Lordship.
Okay.
Now she has admitted that there was a transaction of 3 crore given to Hatatu, who is the proprietor of Kenge Construction, Your Lordship, on promise of the work, Your Lordship. Now, since the work did not complete for a many long time, Your Lordship, there was a settlement between the parties, Your Lordship. And the proprietor, that is the accused herein, has paid the 3 crores 90 lakh, inclusive of the interest, to her firm, Your Lordship.
The accused has to pay.
Has already paid, Your Lordship.
Already paid
Yes.
back.
Yes. There was a settlement between all the parties.
Okay. Already paid back entire amount.
Yes, along with the interest of 90 lakhs, Your Lordship. Now, if I may
Okay.
take Your Lordship to that
Otherwise, the amount was 3 crore.
3 crore. If I may take Your Lordship to page number 103 of the petition, Your Lordship. I'll just read out, Your Lordship. In the matter of work service for induction of certain technical units at F Station Tejpur,
There is type copy.
103, Your Lordship. 105 is the type copy. In the matter of work service for induction of certain technical unit at AF Station Tejpur on engineering, procurement and construction EPC mode, that is the name of the tender, Your Lordship. The following condition has been arrived and concluded. That the total amount calculated as on 4th March 2026 is principal amount is 3 crore and interest amount is 90 lakhs as on date 3 crore 90 lakhs. Sri Hatatu, proprietor Kenga Construction Company, will pay rupees so and so on 5th March and balance amount on or before so and so to Sri Dada Renu, proprietor. If conditions stated in serial number 1 and 2 is failed to executed by the proprietor so and so, then total loan amount shall be calculated as in amount of so and so 2 crore 30 lakhs plus interest, and new total shall be changed into interest of 5% per month. If he pays 1 crore 60 lakhs to Messrs. IM developer. If he pays 1 crore 60 lakhs is not paid by Kenga Construction to IM developer, then the further necessary instruction shall be given to the party and all the witnesses. This mutual settlement has been made by both the parties without any coercion, without any intention, with honest intention in the presence of all witnesses. Your Lordship will see the proprietor is Dado Renu for IM developer. And in the list of the witness, Your Lordship will find in serial number 3 is the complainant, Khoda Sanjay. Now then, Your Lordship will again come to the CD, Your Lordship, at page number 3.
Just a minute.
CD, Your Lordship, page number 3.
Just a minute. Page number
3, Your Lordship, in CD, Your Lordship. Now, subsequent to this agreement, Your Lordship, the proprietor whom the work was given, Your Lordship, has
This
stated
agreement was entered when?
it was entered on 4/3/26. 2026, 4/3/2026.
Okay.
Your Lordship will find the date at page number 104
Hmm.
below the signature of the respective parties, Your Lordship.
Hmm.
Now, subsequent to this, Your Lordship,
Just a minute.
Hmm.
FIR was lodged, when FIR was lodged?
May,
Huh?
15 May 26.
15 May 26, FIR was lodged.
Okay, agreement enter into
4/3, 4th of March 26. Lordship.
and, okay, and repeat on,
Now, Your Lordship will then find at page number 3 of the CD that Your Lordship has come to the CD, Your Lordship,
hmm,
that the statement of the proprietor of IM developer, she has admitted that the amount that was agreed while this agreement dated 4/3/2026 has been paid to her firm's account, Your Lordship. And there is no dispute between the parties now, Your Lordship.
the sole proprietor. Where is our acknowledgement? Where she stated that she has
Down
received?
below, Your Lordship.
Hmm. An amount of rupees 3 crore. That's a subsequent total amount of. Now, if there is nothing, then you will have to file final report.
Therefore, Your Lordship, I have pink mark after the examination of accused, Your Lordship. There's a pink flag mark, Your Lordship. There is an observation made by the IO after the statement of the witnesses, Your Lordship, and the accused, Your Lordship, that it seems that the complainant has, even after all the thing has been settled, has filed the this, Your Lordship.
So it
Now-
is contrary.
Yes,
Then see,
it's only we are just waiting if we are not sure as to what further.
no, so
investigation
nothing
will be.
remains. Then
Yes,
the IO will file final report only, FR only. It appears.
yes, it appears, Your Lordship,
Hmm.
because there is an allegation. I have been also served with a copy
So
of.
what is your submission? You are for respondent, private respondent. Nothing remains, it appears.
Yes, Lordship, power of attorney was given to the complainant. Lordship. for work Lordship, not the way, the farm owner of the his wife Lordship.
The wife has also stated clearly, she has received the entire amount.
Enter amount Lordship only, Lordship. So in this connection, Lordship, I was instructed, Lordship, from the record, Lordship, I'm not find any amounts fully paid by the applicant, Lordship, petitioner, Lordship.
No, that she clearly stated 3 crore 90 lakhs she has received
On that
entire amount.
this connection, Lordship.
I also observed that she is playing dual role.
On Monday, Lordship, I will take the instructions. If paid, Lordship, I have no.
No, that-
Lordship, I object first regarding.
For me, Your Lordship, it's purely a civil nature. First of all, the locus
Civil nature only.
locus standi of the complainant. He's neither he seems, because in his FIR he says that to be in partner with, I have involved my wife, that is the proprietor of IM construction. So he's not even the proprietor of who the money should go, Your Lordship. Secondly, that he was appointed as a power of attorney by the firm of the accused here, Your Lordship. And later on it was revoked. Now
Page
it
number
seems
76.
there is a dispute with business rivalry dispute, Your Lordship.
Now
It
see,
cannot be put to-
IO also, it appears that IO has also understood the matter.
entire matter. Your
And then IO has also in his case diary made an observation, must have seen. The complainant, the present informant, has played a dual role in the present case.
For me, it's completely a civil nature.
Mhm.
Just leave it to Your Lordship
Mhm.
discretion, Your Lordship. Because as per my understanding of this case, Your Lordship, this does not hold any water
I am
to.
submitting two authorities wherein it says that
Now,
section.
see, IO is also in your favor now,
Your
here in this case.
Lordship,
And when the case is going to be end,
Lordship.
IO has no option but to file FR only here in this case, it appears,
Lordship, in
from the
fact,
observation and from the statement.
the very
Now, only because the IO is out of station is the only, because the IO is out of station.
Yes.
Because of that, only this final report has not yet been filed. Probably here in this case, final report will file. And if there is any, we can pass order.
Yes.
But then,
I'll leave it to Your Lordship with this, because with regard to only that opinion, otherwise, Your Lordship, but with regard to the WT message, it's nothing reflecting.
it's not a case where the dispute is a civil case, but then IO is forcefully trying to make it a
Yes,
criminal case. It's not a case.
Genuinely
IO is,
understood the
IO
entire
is,
case.
here, I think, she probably after recording the statement, hearing the parties, I think clearly observed.
Yes,
And it seems that the intention is to file final report only.
seems.
Now, it's not going against you.
Lordship, the very.
So let us wait for some time. Let the IO file. We'll,
Yes, Lordship. Lordship, since I am in fact your Lordship, I am victim in this case. because
now IO cannot change.
The very motive of the complainant, the respondent number 2 here in this present petition, there is a clear-cut malafide, Lordship. Only to
Let him,
harass,
let it be.
Lordship.
Let the IO file, and thereafter, for if there has been any wrongful prosecution, we have always remedies. So I think it's better for you also to wait for some time. Let the IO submit. It's different, questioning by the court and the IO filing, like the difference discharge and the acquit. So you will have the better says thereafter, I think. Because it appears that the FIR is a false,
Yes. That's
on the
fine.
false fact. It will be, if anything done to you, it will be wrongful prosecution.
Lordship.
I think better wait for some time, because in any case, you are not going to be affected by pendency of this case, because there is nothing against you. Only the WT message says that IO is out of station, KSRE could not be updated, and probably when he is coming back, no information.
I have no idea. This also we have got just this
Ah.
morning, Your Lordship. Since the updated CD was never called for on the earlier occasion, on the last occasion, only on my request, because this
Okay.
matter has been pending for a very long time.
Had this been the case where IO is forcefully trying to make it the case into criminal, we would have protect and pass order, but then that is not required here. Wait for some time. Later, I will say that fix another date for updated CD. By then, probably IO will file, since there is nothing, IO may file final report.
Because if there is no anything is not found against the petitioner also, the police will file the final report in favor of him. So, and I also take the instructions whether the money is paid will be paid over.
Because after receipt of the money only, the husband has filed. That's just something. He wanted to implicate
The
trouble.
money
He wanted the trouble.
Yes, the account in which money has been transferred, the account owners has stated that they have been fully
Account
paid.
already received account. Okay.
Maybe Lordship may fix this
Ha-
matter on India.
Had Mr. Titaba, Land Council for the petitioners. Also had Mr. P. Gini, Land additional PP for the state respondent. Yeah, yeah, no. Stop, huh?
17
And Mr.
17 September.
I Bam. No, G Bam,
No, that-
Land Council for appearing on behalf of the respondent number 2. Stop, huh? Para.
No, 17 September.
Miss Gini, semester.
Yes, 26 September.
She has a case diary dated, scanned copy of the case diary up to 28 July 2026. However, as the IO of the case is out of station, the updated case diary could not be procured.
September.
Stop.
Lordship.
Mr. G. Bam, Land Council for the respondent number 2. Also prayed for some time to obtain instruction regarding the repayment. If the repayment, if the farm or who has received.
Lordship, basing farm lordship, wife of a
Okay, well, you are representing the complaint, okay. If the wife of the informant has received back the amount of rupees 3 crore 90 lakh. Stop, huh? In view of the above, and as prayed for by the Land Council for the respondent number 2. And the Land Council for the respondents, comma,
Lordship fixes
Father,
matter on
for the 1 week time or what?
21/9, your Lordship.
Oh,
Because
21/9.
yes, next week I won't
Okay.
be there.
For the 3 week time is granted to the council for the respondent. Stop, huh? As requested, comma, list this matter on
21 September. Your
21/9. Okay.
Lordship, I have.
On which date the additional PP shall produce the updated case diary.
Lordship, since I have a prima facie case, Lordship, my interim may be considered
What interim?
for a state.
No, then they will not file final report.
Finally.
They will not file final report.
If the final report,
There is nothing against you. If that is why I'm saying,
But in the name
given the fact and circumstances of the case, if the IO is trying to implicate you and trying to make or create some criminal case out of this, then we would have protected you. But here it is here the case where it is not required. It is in your favor only. The investigation is going in your favor only. If we stay, you will not file final report.
oh no, there's a recent judgment, your Lordship, by the apex court stating that if even it's no coercive action is to be taken by there is an order of no coercive action, it's still then charge sheet or the FIR can be filed. That
That is there. Nobody prevents.
Yes.
Coercive action is in case of the arrest only.
no.
Against the person only, not against the investigation, rest of the investigation.
In terms of investigation, your Lordship, in terms of because there were.
Is there
issues-
no interim here?
No,
No.
interim.
Okay, not required. Not required.
In the name of investigation, Lordship, the police time and again used to call me before the IO, before the PS.
Then in that case, if you apprehend something,
not
then you can
applicant, because
always come.
arrest is not required in this
Hmm.
case. But in the name of interrogation, I used to be called by the police time and again, despite my full
Now also,
cooperation.
now IO is out of station. Who is calling
No,
you?
not now, but time and again.
Let the IO come, because thereafter only IO has found IO found out this much. And this
no.
finding, I think, is the fact of the case. Okay.
Item number 13.
Diplomate.
Yes. What is this case?
Petition. Based on mutual settlement, lots.
Hmm.
So today it was listed for calling of trial court record.
I think you have no objection. Name corrected.
Yes, name has been.
Then I
corrected.
think we can allow.
Yes, we can allow.
Okay.
So for the TCR, Your Lordship, the stage of the investigation is for there has been someone to the PWs. It seems PW1 has been
What?
discharged after taking his deposition, Your Lordship. So it's in the stage of summoning of the PWs, Your Lordship.
Summoning of the PW.
PW.
Okay. Charge frame now, right?
Yes, yes.
What is the offense?
Offense are robbery.
Robbery.
Robbery. Robbery. Where is the FIR?
Right, yes. Page number 60, Your Lordship.
60.
Yes.
FIR is in 25.
What?
That is charge sheet.
Hmm?
FIR is
You need. This is FIR. Oh, 25 maybe same or charge part of the charge. Same.
part of charge sheet.
Same. Yeah.
Part of charge sheet.
Okay. This is regarding the CPU printer.
It seems both of them have the CSP points.
Business rival.
Business rivalry.
Mr.
Archive.
Learned counsel for the petitioner. Stop. I have also heard Miss Jeannie, learned additional PP, public prosecutor for the state of Arunachal Pradesh. Stop. Para. This petition under section 528 of the Bharatiya Nagrik Suraksha Sanhita BNS B Suraksha Sanhita 2023 as been filed jointly by the informant and the accused, praying for quashing of the GR case number 625/2025 arising out of Nirjuli NRJ PS case number 72/19 under section 392/451/34 IPC pending before the Learned Court of Judicial Magistrate First Class UPIA. Which Judicial Magistrate UPIA? Which one? There are 3 Judicial Magistrate First Class. Which court? Where is the last?
The
one?
PCR.
Not meant. They have also not mentioned.
It's
Hmm?
there in the TCR, you know. Yes.
No,
It's JMFC Capital Complex UPIA.
Okay, JMFC. Is it?
Yes, the last order in the TCR, Your Lordship, is of dated 10 August 2026.
2-3 says that it is a Judicial Magistrate First Class UPIA District of Mubarak.
Yes.
Not mentioned. Last order is it? Okay, then at Judicial Magistrate. Okay, Judicial Magistrate First Class Capital Complex UPIA. Stop, huh? Para. Who is the informant?
To put below. Petition number 1.
The petitioner number 1, Sri Chukwu Talo, is the informant. And the petitioner number 2, Navam Naga, semicolon. Petitioner number 3, Sri Navam Tadik, semicolon. Petitioner number 4, Sri Vicky Hakap. And petitioner number 5, Sri Tar Tango, are the accused in the aforesaid Nirjuli police station case. Number 7219. Stop, huh? Para. The case leading to the filing of this criminal petition is that based on is that the petitioner number 1 lodged written FIR before the officer in charge police station Nirjuli for looting and looting some article including CPU, printer, fingerprint devices from his customer service point within bracket CSP of SBI and for assault. By some unknown person. Stop. Based on the above FIR, the police has registered the aforementioned Nirjuli PS case number 7219 and investigated into staff. During the course of investigation, accused, all of them were arrested.
Arrested.
Okay. The accused petitioner number 2, 3, 4, and 5 were arrested and subsequently released on bail. Stop. Upon completion of investigation, where is the charge sheet?
Page number
The
27, Your Lordship.
Police, the IO, investigating officer submitted charge sheet being CS number 12/2022 on 19/5/2022 against the accused petitioner number 2, 3, 4, and 5 for commission of offense punishable under section 392, 451, 34 IPC. Stop.
Lordship will find the charge at page number 62, Your Lordship.
Page 62 of the,
Petition.
okay. Accordingly, the para, the Planet Trial Code, page 62.
62, Your Lordship.
Took cognizance of the case and framed charge against all the accused applicant number 2, 3, 4, and 5 for offense under section. It's
On-
one head.
Only 392.
Okay. And for offense under section 392 of Indian Penal Code. Stop. Nah. The Learning Council for the petitioner. Now the case is pending for appearance of the accused person.
No, PW's, Your Lordship.
Okay, pending for the examination of the prosecution witnesses before the Learned Court of Judicial Magistrate First Class Capital Complex, UPR. Stop. Para. The Learned Counsel for the petitioner submits that during the pendency of the trial, the matter has amicably been settled between the parties. Where is the agreement?
Page number 64, Your Lordship.
And executed a deed of mutual settlement on 11/5/2026. Stop. The deed of settlement inter alia contains that the informant and the accused persons are running a business of customer service point within bracket CSP at Nirjuli within a radius of 100 meters to each other. Stop. The alleged incident took place due to serious misunderstanding and miscommunication between the parties, and there was no intention or motive to loot or rob the property of the property of the informant. Stop. And since both the informant and the accused persons are distant relatives, comma, with the intervention of the relatives and elders, the matter has amicably been settled. The misunderstanding, sorry, the dispute has amicably been resolved, wherein the informant categorically states that since the matter has been resolved, he has no further grievance against the accused persons, and he does not wish to pursue with the matter any further. Stop. Huh? It is further stated that the informant has undertaken to cooperate for quashing of the proceedings before the appropriate court. Stop. Huh? Under the circumstances, the land counsel for the petitioner submits that the okay, the dispute, the dispute having been settled between the parties, there is no chance of any conviction in the case, and the further proceeding of the trial against the accused would amount to harass both the parties, and in that case it would amount to an abuse of the process. Stop. Huh? Therefore, the land counsel for the petitioner prays for setting aside and quashing of the further proceeding of the GR number 625/2025 pending before the Judicial Magistrate First Class Capital Complex UPA. Stop. Para. Miss Jeannie Lanet, Additional Public Prosecutor, considering the submission of the land counsel for the petitioner. I considered the submission of the land counsel for the petitioner and further submitted that in view of the fact and circumstances stated, and also considering that the matter has mutually been resolved between the parties, and that the informant has no further grievance and does not wish to pursue with the matter any further, she has no objection if the petition, if the prayer of the petitioners are allowed. Okay. Stop. Rest I'll dictate. Much obliged. Disposal.
Item number 14.
Yes,
The same matter, my lord, where
Okay.
the victim appeared.
yes, yes. Here also. I'll just take the name then.
Yes.
It will take time, so. Hard Miss P. B. Marde, Learning Counsel for the petitioner. I've also heard Mr. T. Ete, Learned Additional PP for the state staff. Huh? Okay, let him be. You have a long one. Okay, hard Miss B. Marde, huh? Learning Counsel for the petitioner. Also had Mr. T. Ete, Learned Additional PP for the state staff para. This application under section 528 of BNSS has been filed jointly by the informant and the accused, praying for setting aside and quashing of the, where have you mentioned the GR case number 682/24 arising out of ITA WPS case number 31/2024 under section 498A IPC. Stop. Huh? Where the petitioner number 1, informant, is the wife, and the petitioner number 2, accused, is the husband of the informant. Start. Huh? It is submitted that, sorry, the case leading to the filing of this criminal petition is that due to the family dispute, the informant wife lodged a written FIR before the officer in charge, Women Police Station, Itanagar, against her husband, against her accused husband, alleging that she has been subjected to a physical assault and mental torture and repeated intimidation. Criminal intimidation, stuff. Based on the aforesaid written FIR, the police has registered the aforesaid ITA Women PS case number 31 under section 498A IPC, and investigated into staff. Upon completion of charge sheet file here also,
Charge sheet, my lord,
I think.
yes, my lord, charge.
Oh, yes. Upon completion of investigation, the investigating officer has submitted charge sheet being CS number 63
63 of
2024 on 31/7/2024
yes, ma'am.
against accused petitioner number 2 for commission of offense under section 498 within bracket capital A stroke 323 IPC. it has, what for it is pending?
It's pending for pending trial, my lord. Charge frame.
Charge already framed
Yes,
here.
my lord,
also.
will
It's
find
all
in
the same
number
only.
23.
Same like the last. Okay,
Yes, my lord, because the next date is on 8/10/26.
810.
26.
Okay.
It's for PWS, projection witness, my lord. On 28/7/26, my lord. The order they have annexed.
Mm-hmm. Okay. The Learned Judicial Magistrate First Class. UPR has taken cognizance of the case and framed charge against the accused. Do we have the copy of the charge framed against the accused?
My lord, that they have, perhaps they have not annexed, my lord. My lord, but on the record itself, my lord, the from page number 23, my lord, is 498A only, my lord, because on the margin line, my lord,
Okay, under section 498A IPC. And the case is now pending trial before pending trial. Stop. The learned counsel for the petitioner submits that since the informant and the accused being wife and husband, comma, the matter has amicably been resolved between them. And on 10 August 2026, a mutual settlement deed was executed, whereby the informant has expressed that whereby inter alia it is contained that it is contained it is stated that the the incident occurred due to the serious misunderstanding between the wife and husband, and now they are happily staying together with their minor child. So, and since the matter has since the matter has already been settled, mutually been settled, comma, the informant expressed that she has no further grievances against the accused petitioner number 2, and that she does not wish to pursue with the matter any further. Stop, huh? In order to ascertain the fact of the mutual agreement, the informant petitioner number 1 was summoned to appear before the court. Stop. In compliance of the before the court on 24/8/2026. Stop. In compliance of the said direction, the informant appeared before the court today and stated that the incident occurred due to some misunderstanding between her accused husband. However, now they are staying together happily with their minor child. She further stated that she does not want, since she has no further grievance, she does not wish to pursue with the matter any further, and therefore prays for closing of the matter. Stop. In view of the above, learned counsel for the petitioner submits that under the circumstances. Submitted that the matter is purely a personal and does not affect the society at large. And since the matter has amicably been settled, there is no scope of the conviction of the accused. Stop. And if the proceeding is allowed to be continued, it will harass both the wife and husband, and both the informant and the informant wife and the accused husband, and in which case it would amount to an abuse of the process. Therefore, she prays that the further proceeding of the aforesaid GR case be set aside and quashed. Stop. Okay. And your
Yes, madam.
submission also will be recorded. That
Yes.
is no objection.
Yes, madam.
Okay.
Yes.
I'll dictate the rest.
Yes, madam.
Okay.
Deeply obliged.
Item number 15.
My lord, the CD was called for and interim was extended to the accused person, my lord, to appear before the IO.
Mhm.
And my lord, we have received the case diary, my lord, and he appeared, my lord, before the IO.
He appeared.
21st of this month, he appeared, my lord,
Okay.
and his statement was recorded, and his, my lord, custody interrogation is not required, my lord, as per the IO.
Okay.
My lord, my pre-arrest bail may be. My pre-arrest bail may be, my lord, made absolute. No, since there is no any requirement of any custodial intervention.
He was not shown arrest also, my lord.
Not on arrest.
Yes, my lord.
Okay. Can we make
Absolute, absolute,
Okay.
yes.
Had Mr. H. Lampu, Lana Council for the petitioner. Also had Mr. P.A. Lana additional PP for a public prosecutor for the state of Arunachal Pradesh staff. Para.
FIR is 13.
Okay. Just a minute. This application has been filed by the applicant under section 482 of the BNSS 2023. No. Who filed this application? Elder brother. Sorry. Just a minute. The petitioner, who is stated to be elder brother, has filed this application under section 482 of the BNSS, seeking, Is it elder brother?
No, elder brother. Yes, ma'am. My lord, what happened, my lord, in this case, my lord? This accused person who was arrested, my lord, in connection with Nirjuli PS, my lord. This is the
Okay, he is in custody, otherwise in connection with other PSK.
Yes,
yes,
madam.
That is why.
Yes,
Yes.
ma'am.
And I thought AB, how
Yes, yes.
elder brother can
At
represent.
that time, my lord, he was at custody, my lord.
Okay,
But he
After
was
filing-
released on bail, my lord. Now,
okay,
Bail was granted by this court only, man.
only, my lord. Yes, ma'am.
Regular bail, my lord. The Nirjuli one, my lord, equity theft case.
okay.
Yes, ma'am. Total,
The petitioner, who is stated to be elder brother of the accused. What is the name of the accused?
Khoda Tako.
Kyoda Tako.
Kyoda Tako.
Kyoda Tako. File this application under section 482 of BNSS. Seeking pre-arrest bail to the accused in connection with Itanagar PS case number 212/2026 under section 305B of the BNS 2023 stuff. The application has been filed by the elder brother as the accused Kyoda Tako. At the time of filing this application, application was inside the jail custody in connection with some other police station case. Stuff. Para. Okay. By an order dated 14/8/2026, the accused was granted. Just a minute. Will sir, one line statement for regarding the offense also, huh? Stop. And the allegation against the accused. Where is the FIR?
FIR is certain. This is in fact missing report, my lord.
Or missing report?
Yes, ma'am. Which has later on, my lord.
Missing of what?
Missing of a scooty, my lord. TVS and top scooty.
Missing report. Do you like to inform me that TBS? Some connection, interconnection was there here in this case. I don't exactly remember.
My lord, actually what has happened, the FIR was initially registered at Itanagar PS. The vehicle was stolen, and by the time by investigating the other case,
In the process of investigating, okay,
they were arrested in other case.
okay,
And the scooty was recovered, which was against which there was a missing report, the present FIR.
okay.
And the scooty was handed over to the IO of this case, my lord. And
Okay,
he was arrested in my lord, Nirjuli PS. In that case, BA regular bail has been granted by this court. And during the pendency of this bail, my lord, they have filed this anticipatory bail,
Yes, yes.
and interim protection was extended, my lord. The vehicle has been recovered, my lord, in this case.
Okay. Okay, by an order dated 14/8/2026, the accused was granted interim anticipatory bail and directed to release and directed that in the event of and directed to release him in the event of his arrest in connection with the aforesaid Itanagar PS case number 212/2026 with certain conditions, one of which certain condition stuff. The one of the condition was that the accused, one of the condition was that the accused was directed to appear before the investigating officer within 10 days. And thereafter appear before the IO of the case as and when called for. Stop, huh? It is submitted that in compliance of the said direction, comma, the accused appeared before the investigating officer on when?
21st.
21st,
Yes, ma'am.
21,
Eight.
2026. Stop, huh? On such appearance, comma, the investigating officer has recorded his statement and as however he was not formally arrested. However, he was not formally shown arrested. Stop, huh? Para. The line additional PP referring to the case diary submits that the accused appeared before the investigating officer and he was examined and his statement has been was recorded. Stop. He further submits that since the scooty, the alleged stolen scooty has already been recovered and the accused is cooperating with the investigation of the case, comma, his further custodial interrogation is no longer required. Stop. In view of the above, and considering that the accused, considering that the only allegation against the accused is that the alleged missing scooty was found in his possession and the same has been recovered and handed over to the lawful owner, and also considering that the accused, the applicant is cooperating with the investigation and the IO has also indicated that the custodial interrogation of the accused is no longer required. And stop. And also considering that there is no any allegation of violation of any bail condition, comma, this court is of the view that, of the opinion that the applicant is of the view that the applicant has made out a case for extending the privilege of pre-arrest bail. Stop. Accordingly, the interim order passed
14/8.
on 14/8/2026 be hereby made absolute with the same bail bond with the
Same conditions.
same bail bond and condition with the further condition subject to the following terms and condition. Stop. That the accused shall continue to appear before the investigating officer and cooperate with the continue to cooperate and appear before the investigating officer as and when called for, 2, that the accused shall appear. Just a minute, that the accused shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case. 3, that the accused shall not commit an offense similar to the offense of which he is accused of. Next, that he shall not directly or indirectly attempt to tamper with the investigation or tamper with the evidence of the case in any manner. Stop. With the above, this bail stands disposed of.
Yes. Obliged.
Obliged. Deeply obliged. Item number 16.
May it please your lordship, I am appearing for the petitioner in this case.
Yes.
Lordship, this criminal petition has been filed for quashing of the order dated 27/1/2026 passed by the learned judicial magistrate first class Papampare, whereby my criminal case was complaint case was dismissed. Your Honor,
May I submit in between, Your Lordship?
Yes.
Your Lordship, I'm appearing with a respondent, Your Lordship. Mr. Jal Alam is supposed to appear today, Your Lordship, but today, Your Lordship, due to the rain, Your Lordship, and he stays at 6 Mile, Your Lordship, and that's why that area is mostly affected due to water logging, Your Lordship. That's why he's not able to appear today personally, Your Lordship, and submit before Your Lordship. Kindly an adjournment be given, Your Lordship.
otherwise, the matter is very simple, Your Lordship. They may be directed to appear before the department and follow the summons under the Section 70 of the CGST Act. Your Honor, they have appeared before this court on the same address, but they are not appearing before the department under Section 70 of the GST Act. So they may be directed to appear before the investigating authority, and this petition may be disposed of in that terms. Because an allegation has been made against them, they are not appearing before the department. Now, after that, we have filed that complaint case. The complaint case was dismissed. By challenging that order, we have approached this court, and now they have appeared before this court. They can appear before the IO. They can very well submit their reply.
Your Lordship, let the matter be heard, Your Lordship. Both the parties may appear, Lordship, as Mr. Jad Alam is supposed to appear, Lordship. He will make the necessary submission, Your Lordship. Kindly an adjournment, Your Lordship.
In that case, Your Honor may kindly fix a short date, because this
On-
matter
yes.
is lingering from a very
On-
long time.
Yes, sir, on 8th of September, Your Lordship. If the other
Okay.
side is not any
Mr.
objection.
K. Jain,
Mr.
K. Jain, Kaushik
Learned
Jain, Your
counsel for
Honor.
the petitioner. Miss
S. Nazneen, Your Lordship.
S. Najnin, Learned counsel, submits that who was to appear? Mr. KL.
Jed,
Yes. No. I'm appearing on
not
behalf
for
of
the-
Mr. KL.
For the respondent, I'm submitting for Mr. Jed Alam, Your Lordship. Jed Alam. Alam.
Okay. In the present case, Mr. Jed Alam was to argue the matter. However, due to some transportation problem, he could not reach the court today. Therefore, she prays for adjournment of the matter for the day. Stop. The prayer is allowed. Stop. As requested, list the matter on
8th
again
of
on
September, Your
when?
Lordship. 8th of September, Your Lordship. 8th of September, Your Lordship.
Is it okay? Okay. 8 September. Yes.
Deeply obliged, Your Lordship.
Much
Item number
obliged, Your Honor.
17.
Wait, please, Your Honor, in item number 79 for the petitioner, here we have filed this criminal petition for quashing of the investigation. It's an affair of 21 of 26, dated 26/4/2026, registered at Nirjuli Police Station, Papam. We have taken the
Lordship,
steps this matter,
Notice
but
upon respond number 2, Lordship, yet to be completed. And moreover, we have case study has not received yet, Lordship.
Okay. Mr. Jain.
Your Honor, Your Honor, I'm just submitting that the respondent number 2 has filed one IA for seeking cancellation of bail. in my EB, which has been made absolute by this court. So I pray for a stay of the investigation, Your Honor, because they held that a criminal for cancellation of my EB, which has been granted by this court. This FIR is arising out of a civil dispute. Now they have given of criminal nature, Your Honor.
What is this? Who is private respondent?
Private respondent, Tabia Chania, respondent who had FIR for the Nirjuli station.
Mr.
K. Jain, yeah.
K. Jain, Land Counsel for the petitioner. Also had Miss L. Hage, learned additional PP for the state staff. The trial court, the court. No. What about the private respondent? The
Case study lost.
notice upon the private respondent, which is still awaited. No, press step not taken.
Your Honor, we have taken the first steps.
When?
Was last listed on.
Okay, press steps not taken. Taken. It return unserved. Insufficient address.
But Your Honor, we have taken the address based on the complaint filed by them, and now they have approached this honorable court. Have taken on 27, 2026.
Okay. So the same date.
Same day, Your Honor. The only difficulty is that they have filed that IA criminal for seeking for cancellation of our EB. So in that view of the matter, Your Honor, I pray for the interim.
No lordship. Now it is in this stage lordship, no interim lordship. Let
No.
this case study
The postal trade.
may lordship
Now
produce and
now I am,
step may
Your
be
Honor, I am
completed.
apprehending arrest now.
The service upon the respondent is still awaited. Stop. The case, the scanned copy of the case study called for is also still awaited. In view of the above, let this matter be listed again after 2 weeks, on which date the additional PP shall produce the case study.
It can
Scanned
copy
copy of the case study.
No,
Your
sir.
Lordship, I have a small submission. Then this matter may be tagged with IA criminal 72 of 26.
Where is that?
Yeah.
List the matter
I
again
have the
after-
case number IA criminal
How it is connected?
because they have filed the cancellation on the same FIR because we have been granted absolute bail by this honorable court. Now they are challenging our bail, which has been granted absolutely.
Oh, Learned Counsel.
IA criminal
How
has been
IA
filed by the private respondent.
Okay,
Private
leave it.
respondent, who is the
Okay,
respondent
sure.
number 2?
Next.
Who is the much of
Item number 19.
Sorry, my lord.
Yes.
May I make mention, my lord? Item 20 is ready for hearing, but it seems that time is not. So therefore, my lord, this may be given one fixed date, that is 18. 16th of September.
16.
Yeah.
This is a criminal petition.
Criminal petition. Only this is listed for the argue on maintainability
Okay.
on the last page. But
Okay. Due to heard Mr. Minky Boje, Learned Counsel for the petitioner. Also heard Mr. Okay, yeah,
I'm for 4, 5 and 6.
and who is for the,
I'm for 2, respondent
Two.
number 2.
I'm for state law.
okay, Miss El Hage for respondent number, El Hage and additional PP for the respondent. Mr. Seri Gatso for respondent number 2 and Mr. Yadav. Are we other for respondent number
4, 5 and 6.
4, 5 and 6? However, due to, no, with their presence, Mr. So-and-so, Land Council for the petition, so-and-so are present. However, due to positive time, the matter could not be heard. Okay. Sub-page requested, list the matter again on 16
September.
16 September. Okay.
Lordship,
For hearing.
scan copy of the TCR may be called for lordship.
Not called for yet.
Not lordship. Only
Is there any stay, etc.? No.
no lordship.
The scanned copy of the Jimma application, trial court record was called for, but it's not.
It's not received yet. Lord.
19 is also connected.
No.
Only 20 lordship.
Only 20.
No. Are we in 20 or
We are in 20.
20?
Since,
Only
I
20.
don't know.
Why you are giving 19? Oh, okay. This is 20.
Since in item number 2,
Okay.
it's going to take some time.
Okay. Trial court record. Not yet received. No, I think the trial court record already called for.
Oh, yes, Lord, it's not yet received. Lord.
Okay.
Reminder
On which
sent,
date?
Lord.
On which date? Not yet called.
No, called lordship, but it's not
Okay.
received yet.
On which date the line? 16. On which date the line? Okay. On which date the? Sorry. Then say one code. The trial court record is called for has. Now right heard only. Then not present. The trial court record is still awaited. Because even if there is a time also, in absence of trial court record, we cannot hear it. Okay.
And lordship,
In view
moreover,
of the above, and as prayed for, in view of above, the registry cell issue reminder staff, as requested, come and list the matter on 16.
and lordship, on the same date, lordship, I may be allowed to produce a scanned copy of the updated case diary.
Yes. Trial court record, you said?
No, trial court record for Jimma lordship that record, but scan copy because it's still under investigation lordship.
Is it?
Yes, lordship. So that I may
Then-
be allowed to produce updated case diary.
Then trial court record still awaited staff. The it is submitted that the case diary would also be necessary. Staff, in view of the above, call for the scanned copy of the case diary.
Yes, lordship.
Okay, staff. As requested, list the matter on 16.
Lordship.
Okay.
My lord.
Yes.
Item 19.
My lord, this is an
Appeal.
My lord, this is an appeal against acquittal. I am the victim. Since I was a minor, so I have been represented by my mother, my lord.
But the hearing, I think it will take time. I have a meeting also, I'm informed.
Okay. My lord, if
Sir, we have discussed 7th already.
in that case, my lord, let this matter be listed on a fixed date, my lord.
My lord, if I may be allowed to just begin with just to read the FIR and just to lay the ground foundation on which I will be arguing the case, and then it can be
What is that?
taken up on the 7th of September, my lord, for the hearing.
7.
Continued.
7 would be little difficult.
It's a Monday.
Election petition, because hearing would be difficult.
My lord, on the previous date also matter was listed, it could not reach.
Now, what can we do?
Exactly, my lord.
My lord, let it be on a, my lord, then you fix it a specific date, my lord. We'll go for my disposal of this case, my lord.
My lord.
4th is too early, my lord. 4th is holiday. 4th is holiday. Let it be on 9th, then for the 9th.
My lord, I was requesting 7th for one reason that we'll be traveling from outside and coming.
No, 7, we have election
Election
petition.
petition.
Then
Election
it,
petition, my lord.
it will not reach. No.
My lord, 8th is a DB.
7, 8 and 9 are election petition.
Okay.
7, 8 and 9 election petition.
Then let it be on, my lord, 11th, my lord.
11 is a Friday.
Yes, my
11th is a Friday.
same day like today itself.
11 would be difficult
10th, my lord, then
this time. 10,
after DB.
10 can be.
My lord, 10th is a DB. 10th would be a DB.
10 DV, but I have no idea, but it also depends.
My lord, if it is DB, then less matter will be listed. Then
If less matter is
Don't-
listed before the DV,
Yes.
DB also is unpredictable.
Yes, my lord, sometimes it
It depends.
rise very early. And
Because they do not know which case will take much time.
yes,
Which
absolutely.
take, take how much time. So that is why it is very difficult also.
Since he's outstation lawyer, my lord, let
My lord, if I can make a small prayer, if my lord would accommodate, my lord, even if it is being fixed on the DV day, the Thursday, my lord, if it can come up at the top of the hearing list, that's my only prayer.
on 10th.
10th.
DB day hearing, normally it is not possible sometimes because other matters also will be there. Motion, admission orders will be there, and thereafter only,
Then-
even if it is listed on top of the,
My lord,
today also you see, hearing did not do, it is
my lord,
almost top.
my lord,
But then-
if we can fix it on the 7th, we can commence and continue on 8th. We can continue on
7th, it
8th.
will difficult, it will be difficult. 7th, not possible at all, no point getting listed.
My lord, I could have continued to 8th and 9th. We could have continued.
7, 8,
It
9.
becomes very, because in the entire afternoon will be covered by the election petition and no matter remain.
My lord, then let it be on 14, my lord. 14th, Monday.
Let me on 10,
My lord, can it be then on 8th? It's a DB day, my lord, but
Okay, 19.
Yes, my
What?
lord.
No, no, no.
My lord,
That-
let it be on, my lord, the 14, my lord. What?
Okay, okay.
14, let it be on 14 on
14,
Monday, my
okay.
lord. Otherwise, my lord, no one will be ready with the date, my lord. Let it be once for all 14, my lord.
Mr.
Monday itself.
Mr. So, what? Yes.
And Khera.
And Khera. Your name is also not there, Mr. Khera.
my lord, my name is there. It will not be reflected in the cause list. My colleague here filed. I've signed the wakalatnama. But
Okay.
But it as agreed by the constitution, after the duty is on 10, we'll see if it can be possible. We can.
What is it difficult? 2 days, for 2 days. Let it be on 14th.
Okay, okay, okay. Hard, Mr.
N. Khera, my lord.
Carolina Council for the applicant. Also hard, Mr. Ete, Lana additional PP for the state, and Mr. Taja for the private respondent.
Yes.
Respondent. On, on the prayer, on the request of the party, come at least the matter again on 14. I will say due to positive time, the matter could not be heard, huh? So, on the request of the party, please the matter again on 14th. Okay.
Obliged, my lord.
Item number 21, unlisted motion matter.
21 is also there.
Motion.
May I please talk?
Yes, what is this case?
Lordship, this pre-arrest bail filed by applicant, Lordship. Lordship, applicant apprehends his arrest in connection with PS case 123 of 2025, dated 05/09/2025, registered under section 318 for BNS, it's cheating. And Lordship, the case arose out of dispute concerning the monetary transaction between the
Where is
informant.
the FIR?
FIR, Lordship, FIR is in page number 34, Lordship.
34?
And tab copy is in 35, Lordship.
Good. My lord, here, my lord, one of the co-accused, his criminal petition was recently, my lord, dismissed. And secondly, my lord, the anticipatory bail was also withdrawn since he was arrested, my lord. And NBW has also issued a-
Co-accused?
co-accused, yes, my lord, the Rakesh Kumar Singh, my lord.
Okay.
Your lordship will find in the order itself, my lord, because this case required, my lord, the proper investigation, and your lordship will find in phase number, my lord, in their petition, my lord will find in phase number, my lord, 54, my lord. The finding of this honorable court in the criminal petition, my lord.
Criminal petition, what happened to
My
criminal?
lord, it was dismissed. Criminal petition was dismissed against one of the co-accused, my lord. They are involved, my lord. They are both involved, mentioned there. Case diary was considered, my lord. Para 23, my lord.
Para 22.
Lordship,
Page number 54.
Lordship, my humble submission is
Just a
that
minute, huh?
I have also perused the relevant portion of the case diary. The investigation officer has stated that the investigation has revealed the present prisoner was the mastermind behind the alleged offense and had projected himself as having contract in the ministry through whom he could secure clearance of informant's bill. It is further alleged that the petitioner subsequently furnished a forged document purporting to indicate allocation of fund by the ministry. The case diary further records that the petitioner has not been cooperating with investigation and that his custody interrogation is necessary. In this context, the additional so and so submit despite interim protection. My lord, this criminal petition was dismissed, my lord. Why I am relying this, my lord? At this stage, my lord, why I am relying it, my lord? Without perusing the case diary, my lord, no interim protection may be extended. Only that is my limited prayer.
We'll call for the case diary.
Yes, only after perusal of the case diary.
Mister?
Lordship, may I, Lordship, just 1 minute, Lordship. Lordship, I have materials to substantiate my humble submission. Lordship, I am not involved in this transaction, Lordship.
What is your name?
Tolok Lombi, Lordship.
It's there.
Lordship, only my farm's account
You,
were
you are
used
named
for
by.
transaction, Lordship.
Hmm?
And Lordship, I have material to substantiate, Lordship. Just
Anyway, we'll
Lordship,
see the case diary because criminal petition also dismissed.
Lordship, interim protection may be given. Lordship,
Observation.
Lordship, I have
I-
already
We'll
appeared
see,
before
we'll see
the
we'll peruse the case diary first, okay? What is the total amount involved? 17 crore.
No, Lordship, 2 crore 40 lakhs 42,000 251.
What is this 17?
Lordship, the matter is, Lordship, it's a monetary transaction between the informant, complainant, and the person area as accused, Lordship, and applicant, Lordship, applicant is.
There are two accused.
There are
Three.
accused, Lordship.
Three accused, my lord. And my lord, is page number 35, my lord will see the date of FIR. It was registered on 5/9/25. Only after arrest of the main accused, my lord, they are now approaching this court, my lord. So there is, my lord, definitely, my lord, there's some suspicion is there, some material will come up against them. So after perusal of the case diary only, my lord may consider their anticipatory bail, my lord. No interim at this stage, my lord.
Lordship, my only humble submission is that the entire transaction, Lordship, I am not involved.
Okay.
My only.
Okay, we have also no time. So we'll call for the case diary.
Yes, ma'am.
Lordship.
That is why it's mentioning it very difficult. Mention it unlisted, it's very
My lord.
difficult. No time. I have a meeting. No time. Only call
And
can call
Lordship,
for
I
case
have
diary.
already appeared before the.
Okay, okay, but then
Halagan.
no time to pass order also.
Where, Lordship?
You target for the target for the mentioning. You could have filed earlier.
22 lakhs.
Same order.
Fact, quite
Same.
different.
Same order.
Lordship,
But same affair.
Same FIR.
And you are which one?
My role is very limited. Even, Lordship, I am.
We'll fix short date. We'll fix short date.
Yes.
Lordship, interim protection maybe.
This case, Lordship.
We'll fix short
Lordship
date.
and
No,
the
because I
target
have
people.
to go. Because there they see the orders. You have also annexed the order. Need to go through. Need to go through.
This is filed by Lordship.
Maybe, but then need to go through the observation. Need to go through the observation and also apply mine
Yes.
on this FIR also. So that is why no time for that.
Lordship,
Difficult. No.
After granting interim, Lordship, that fix of short date, Lord. Because the cases of.
No, after granting interim short date, you don't require.
I am ready to cooperate with the investigation.
You are bound to cooperate. Okay, hard, Mr. Mr.
K. Megalo.
Lani counsel for the petitioner.
Because Lordship, the arrested accused person. had
Also-
issued
Also hard, Mr. Ete, Ete. landed additional PP for the state staff, para. By filing this application under section 482 of the Bharatiya Nagarik Suraksha Sanhita 2023, the applicant is seeking pre-arrest bail, apprehending his arrest in connection with Nahalagan PS case number 123/2025 under section 318 for 3 within 5 of BNS 2023. Staff issue notice. Call for the scanned copy of the case diary. Staff list the matter again. When?
My lord, no antecedent has been disclosed again, my lord.
No antecedent.
Yes,
Then I think planning council,
they should try afresh.
you will not be allowed to file additional. You have to withdraw and file afresh.
Antecedent need to be disclosed, whether any case is pending or not. Any other criminal case, not the application.
Mr. Okay, planning council for the petitioner submits that he may be permitted to withdraw this bail application with liberty to file afresh after making necessary correction, to which Mr. Tilane additional PP has no objection. Accordingly, this bail application stands dismissed as withdrawn with liberty as prayed for. Here also?
Yes.
Same. It's better. You file one day ahead, let the judge
Yes, my lord.
come prepare with at least the FIR. No? In certain, otherwise in the simple case, no problem. But in certain cases, there are complications where involvement, money transaction, all those. So, some might,
Here in this present case,
then,
victim,
the
accused arrested first.
okay.
Obliged.
Okay. In other case, his name.
My lord, I'm sorry.
Yeah.
My lord, the item 19, which my lord is fixed for 14. My lord, if it can come up at the top of the list, please hearing list, my lord. If it
At the
can-
top of the list.